Yes! Hello, my beautiful friends. What an amazing day it is. We have Supreme Court business to attend to this morning. We're waiting for the court to kick things into session. We got C-SPAN queued up. The media is outside the courtroom. Here is what it looks like with a little bit of construction going on the facade of the Supreme Court. And so we're here, of course. The issue today is birthright citizenship. Does the Constitution and the 14th Amendment in particular say that if you are in our country illegally, you're not here with lawful permanent status in any way, shape, or form, and you have a baby, is that baby suddenly a citizen? Here's the president.
To Turkey.
I don't know anything about it. I'm not disappointed in anything. Who are you from?
BBC News.
I'm not disappointed. Why would I be disappointed? We just took in $4 trillion, and he says, are you disappointed about a delegation? I know nothing about a delegation. I haven't even checked. Look, nothing's going to happen until Putin and I get together, okay? And obviously he wasn't going to go. He was going to go, but he thought I was going to go. He wasn't going if I wasn't there. And I don't believe anything's going to happen, whether you like it or not, until he and I get together. But we're going to have to get it solved because too many people are dying. Thank you. You're going to land right now. Thank you.
Thank you, sir.
All right.
That was just earlier today. The peace talks that he was discussing, President Zelensky of Ukraine is in Turkey for that. President Putin is not going to be there. And here's Lori in, is it Kannapolis, North Carolina, Democrat?
Yes.
It looks like Annapolis, which is in Maryland, but there's a K there.
No, it's Kannapolis.
Kannapolis.
Yes. Thank you for taking my call. My comment is, why on God's green earth do American citizens and immigrants vote against their own personal interests just because he said he would bring down the price of eggs? And it hasn't happened. And all the
We didn't vote against our interests, lady.
Found, none of it's written in black and white. It's all just numbers they throw out. And no matter what he said about Zelensky and the war, he was wrong. Why can't we just stick to the facts and not rhetoric? How come we have to...
All right, so she's very upset with the president. We're waiting for the court to get underway. Usually they're on time. It's about 7:03 right now, and so we're wondering if they're going to cut into them, making sure we're looking around on the cables right now, and some of them are covering it. Actually, all of them are covering it. They got Trey Gowdy on Fox News right now. He's doing this Trey Gowdy thing. Trey Gowdy. So he's doing that. We also got MSNBC's outside. CNN is outside. We're just waiting for the court to kick things off. But of course, what we expect to see out of the Supreme Court is for them to just come out and simply affirm the main case. We're going to hear some cases today. Probably Wong Kim Ark is going to come out a lot. You're going to hear that a lot. Wong Kim, Kim Ark, the Ark case, Wong Kim, whatever, coming out. We've gone through that case a lot here today on this channel and have explained how in that case, that was about a Chinese family who had a baby here, but they were lawful permanent residents. And they talked about that throughout the opinion many times over. And for some reason, the perversion of that has been the kind of the status quo has been that if you're in the country geographically, then that counts as enough to be subject to the jurisdiction thereof. Now, I think the discrepancy, the line on this is you're going to hear people say subject to the jurisdiction thereof. What does that mean per se? Well, if they come across the border illegally, well, clearly they're subject to the jurisdiction of the United States because you can charge them with removability, right? Because you can round them up and detain them and process them and charge them with crimes. So they're subject to the laws, right? Is one interpretation of this, which is why they say that the 14th Amendment grants birthright citizenship. But that's not what that means, subject to the jurisdiction thereof. It means that you have subjected yourself to the jurisdiction of the nation state, right? You have acquiesced to their power. You're in compliance with the law. You're not claiming that you're above their law and breaking into the country illegally. You've not subjected yourself to anything, which is why we still have the same precedent that says that diplomats and their babies are not automatically citizens when they just happen to show up here and plop a baby out on our geographic region. And so we're going to see a lot of that, I think, back and forth. My understanding is Trump commented on this morning. And so I was trying to get that here. MSNBC said this, that Trump is snarling. Wow. They say Trump is snarling. He calls it a stupid country ahead of the Supreme Court hearing, which is, right? We've got these two concepts of how birthright citizenship works. We've got this idea of you got to have relation by blood to a parent who is a citizen, right? Which is how most other countries do it. It's not just geography. If you just come over to England or come over to France or come over anywhere and just plop a baby down, many of those countries don't just automatically grant citizenship. And Trump is commenting on that. They say, hours before the Supreme Court is scheduled to hear arguments, we're waiting for him to get started. Wonder if they're having a slow morning. NBC News reported, said the longstanding interpretation has been in place for generations. It's true, but it's wrong. According to the president, the fact that the U.S. has granted citizenship to anyone born in the country makes the country stupid. She's right about that. And oddly plays into the hands of cartels. On his Truth platform, he wrote, big case today. Let's see if this is the post. Yeah, here's what Trump said today. All right, big case today in the U.S. Supreme Court telling us birthright citizenship was not meant for people taking vacations to become permanent citizens of the United States of America and bringing their families with them, all the time laughing at the suckers that we are. The United States of America is the only country in the world that does this, and for what reason? No one knows. Well, and you might say that there was a lot of land that needed to be filled. And so everybody kind of looked the other way on this. They're like, we just need people here. Okay. So if you just have a baby here, you're an American, good enough for us, because we need to fill out the country right back in the 1800s when we had this westward expansion and more. And that has changed. Okay. Now America's at capacity. Thank you. But the drug cartels love it. So do the Chinese, by the way, right? There's this concept called birth tourism where they just fly people over here so they can plop a baby down as soon as they land. Saying, we are, for the sake of being politically correct, just to be clear, he doesn't want to offend anybody, we are being a stupid country. But in actuality, this is the exact opposite of being politically correct. And it is yet another point that leads to the dysfunction of America. Trump says, birthright citizenship is about the babies of slaves. As conclusive proof, the Civil War ended in 1865. The bill went to Congress less than a year later in 1866, and it was passed shortly after that. It had nothing to do with illegal immigration for people wanting to scam our country from all parts of the world, which they have done for many years. It had to do with Civil War results, and the babies of slaves, who our politicians felt correctly, needed protection. So please explain this to the Supreme Court of the United States, John Roberts. Again, remember, the Civil War ended in 1865, and the bill goes to Congress in 1866. We didn't have people pouring into our country from all over South America and the rest of the world back then. It wasn't even a subject. We had, at the time, babies of slaves. Thank you for your attention to this matter. Good luck with this very important case, and God bless the USA. And that's exactly right. Now they're trying to use that provision to say that everybody from everywhere all over the world can come in here and just suddenly have citizenship when they drop a baby here. Like, why did the Chinese get the privileges of the 14th Amendment, which was not enacted for them? Well, we're going to find out what the Supreme Court says about this. And they're running late over there. So let's see what they have reporting here for us over on C-SPAN.
Through the right lens on Birthright. Basically, it's subject to the jurisdiction thereof. And this was solely meant to refer to, classes of people defined and seen by their origin in 1868. Their origin, like blacks, resident Chinese immigrants, Indians, those with historical legal presence and no counter allegiances. That's what it was meant for, And what they did is they had this case, U.S. versus Wong Kim Ark, where they made it all about the geography. If just somebody shows up here, which doesn't make any sense, because if you had an invading army, do you really think that that's what they would have meant? That just any kids of anyone that just shows up geographically here becomes a citizen. And see, it really just all comes down to citizens. A lot of people don't see that. I think that's the biggest division here, is that there's a lot of people here that were citizens, and we don't want to see just this endless altruism to the entire world at the expense of our fellow citizens. And there's a point where, you know, we can't take on the entire world.
Absolutely.
And then there's another aspect to this case, which is all these injunctions, you know, and there's this establishment, elitist kind of judicial thing going on where they're just ruling on whatever they on their whims, on whatever they want. They're not
Shout
really
out to this
following
dude
the
from
law,
California,
and they're just trying to obstruct who we all decided to be president, and just completely delaying his entire presidency, probably indefinitely. And so I think that it's all about cheap labor and big business and keeping all of these keeping all that cheap labor here at the expense of the rest of us. And I think that they didn't necessarily get everything right a long time ago. And I think the interpretation of the 14th Amendment is where they really got it wrong.
All right, Joseph. Here's Ian, South Carolina.
Yeah, great call from California. That dude was on point. And I think that he's right on many of those points. And I think one point in particular is that the interpretation of even Wong Kim Ark, like Wong Kim Ark is pretty clear. We read it here on the channel and saw explicitly that it talked about his parents being lawful permanent residents. They came into the country, they subjected themselves to the jurisdiction of the nation, and then they had a baby. It wasn't they broke into the country or was just here temporarily visiting or something and then plopped the baby out. Now, a lot of people are showing up out there, and hey, shout out to Quell over on Locals is explaining right now what they're doing is bar admissions in the Supreme Court. And so they're just doing some basic business before we get started. And SCOTUS blog seems like she's in the room live posting about that. So we'll come back on that in a minute. But let's take a look at the crowd out here. Who are some of these people? Some of these signs look like something like I saw Trump must go up at the front, and they've got other callers in there right now. The cables have pulled away mostly from any of the coverage on this for now, but other signs, lots of media. Looks like it's filling out a little bit. Let's check in with SCOTUS blog and see what they've got cooking for us, because they have some live updates as well. So here is their crew who's live blogging it from inside, I think, the courtroom. Kagan is issuing some opinions. We have a unanimous decision that just came out in Barnes versus Felix case. Not that Barnes, I don't think. This guy David says he's got gastrointestinal issues, and he's triggered by the phrase irregular docket. He says, are you talking about me on the irregular docket? It's not good, David. Hopefully you get that resolved. Greetings, says Anthony. And there's a bunch of stuff cooking over here. So they're posting some updates, and there's a chat happening over there. And there's going to be releases, but then they got the background for us. All right, so this is the main case that we're going to be hearing from today. It's a consolidation of a bunch of cases. So the birthright citizenship issue has popped up in many different courts all over the place. You can see here's the docket as we get here today. Bunch of people coming skidding in here as well. We've got Iowa, America's Future filed a brief. Tennessee filed a brief. David Boyle, National Security, members of Congress filed something back in March. All of these additional amicus, West Virginia's here, some professor, legal historians. Everybody wants a say on this. And of course, we're here on the CASA case, and I think there's really consolidated cases here too, with Trump versus Washington and Trump versus New Jersey, all here. Now, we're also asking ourselves about the injunction issue, right? And it may not even necessarily be about birthright citizenship, which is where we go, because there's another kind of sub-issue. Oh, an argument's live. All right.
Issued 40 universal injunctions against the federal government to win everywhere, while the plaintiffs can win anywhere. They invert.
Let's go here.
That has now spanned the last 5 presidential administrations. Universal injunctions exceed the judicial power granted in Article 3, which exists only to address the injury to the complaining party. They transgress the traditional bounds of equitable authority, and they create a host of practical problems. Such injunctions prevent the percolation of novel and difficult legal questions. They encourage rampant forum shopping. They require judges to make rushed, high-stakes, low-information decisions. They circumvent Rule 23 by offering all the benefits but none of the burdens of class certification. They operate asymmetrically, forcing the government to win everywhere while the plaintiffs can win anywhere. They invert the ordinary hierarchy of appellate review. They create the ongoing risk of conflicting judgments. They increase the pressures on this court's emergency docket. They create what Justice Powell described as repeated and essentially head-on confrontations between the life-tenured and representative branches of government. And they disrupt the Constitution's careful balancing of the separation of powers. I welcome the court's questions.
Let's go.
General Sauer, these universal injunctions, as you say, have proliferated over the last 3 decades or so. Would you discuss, though, the origins of universal injunctions? In particular, I'm interested in sort of historical analogs or the historical pedigree, particularly the Bill of Peace that was proffered by respondents.
Interesting.
Yes, Justice Thomas, as you, I think, first pointed out in your separate opinion in Trump against Hawaii, the Bill of Peace is something very distinct from a universal injunction. So the Bill of Peace involved a resolution of a small, discrete set of claims of a small, discrete group, and even more fundamentally, it was binding on the members of that class and those represented by the class. So it's much more analogous to a modern class action under Rule 23. And in fact, as we've argued in other cases, and as this court has described in opinions like Ortiz, the Bill of Peace evolved into and is directly developed into, so to speak, the modern class action that has all the same features of a Bill of Peace. So in the words of Chief Judge Sutton in the Sixth Circuit, the Bill of Peace, it was a domesticated animal that looks nothing like the dragon of a universal injunction.
I'm sorry. Here,
Go ahead. Sotomayor?
Here, there's a discrete identified group on one issue. Does citizenship mean are you born in the territory of the United States, or does it mean are you loyal to someone else, which is your claim, or are your parents loyal to someone else? So that's no different than what happened in a Bill of Peace. The United States is bigger, so it extends more broadly, but it's still an identifiable group on a discrete, singular question.
Your Honor, I'd say 3 things in response to that. First of all, our primary contention is that the Citizenship Clause related to the children of former slaves, not to illegal aliens who weren't even present as a discrete class at that time.
Thank you.
But more fundamentally here, as to the issue of the Bill of Peace, there are critical differences. The Bill of Peace was a binding judgment that would bind absent class members. Here we have the asymmetry.
Well, here, class actions don't bind anyone who opts out, so class actions are not like bills of peace.
I would think that a Rule 23b2 class action, which would be the relevant analog here, would be one that would be binding on absent class members and would not have the same notice and opt-out procedures. And more fundamentally, that sort of argument that there's a commonality here among, all the people who purport to be affected by this is the sort of argument that's made in class certification.
So can I ask you a question? Your theory here is arguing that Article 3 and principles of equity both prohibit federal courts from issuing universal injunctions. Do I have your argument correct?
We argue both of those. And
you argue both of those?
Yeah.
If that's true, that means even the Supreme Court doesn't have that power.
The Supreme Court would have the authority to issue binding precedent nationwide, but
we couldn't enforce it against universally, is your argument.
If there was a decision that violated the precedent of the court, then the affected plaintiffs could get a separate judgment.
And that means you're talking about the hundreds and thousands of people who weren't part of the judgment of the court. They would all have to file individual actions?
Yes.
Not necessarily.
Or a class action.
A class action would be the way
that makes no sense whatsoever.
Respectfully, we believe that.
Well, what was the purpose of the Bill of Peace if not to settle a legal question finally? And if even the Supreme Court doesn't have that right and must invite hundreds of thousands of lawsuits, what are we buying into?
If a set of claims satisfies the rigorous criteria of Rule 23, Rule 23 is the modern analog of a Bill of Peace. We have something very different here.
No, we don't, because the argument here is that the president is violating not just one, but by my count, 4 established Supreme Court precedents. We have the one ARC case where we said fealty to a foreign sovereign doesn't defeat your entitlement, your parents' fealty to a foreign sovereign doesn't defeat your entitlement to citizenship as a child. We have another case where we said that even if your parents are here illegally, if you're born here, you're a citizen. We have yet another case that says even if your parents came here
What case was that?
And were stopped at the border, but you were born in our territory, you're still a citizen. And we have another case that says even if your parents secured citizenship illegally, you're still a citizen.
Ridiculous,
so as far as I see it, this order
Overrule
violates
all that.
4 Supreme Court precedents.
That's bad case law.
And you are claiming that not just the Supreme Court, that both the Supreme Court and no lower court can stop an executive from universally from violating those holdings by this court.
We are not claiming that because we're conceding that there could be an inappropriate case.
Only a class, only
Can
by
I
a
hear
class.
Can I hear the rest of his answer?
Thank you, John Roberts.
A Rule 23 class action. And then the more fundamental point as to all those Supreme Court decisions you referred to.
So what do we do temporarily?
Temporarily, the court may issue, the lower courts may issue injunctions that remediate the injuries to the plaintiffs that appear before them. Lower courts, in appropriate cases, may certify class action.
So when a new president orders that because there's so much gun violence going on in the country, and he comes in and he says, I have the right to take away the guns from everyone, then and he sends out the military to seize everyone's guns. We and the courts have to sit back and wait.
What just happened? C-SPAN just died on us. All right, we got this one queued up. Let's go over here.
Plaintiff would implicate the redistricting throughout the whole case. So throughout the whole state. How does your theory address that situation?
That would be what you might call an indivisible remedy, where what the court is doing there by, for example, redrawing the district lines is, as this court said in Gill against Whitford, the only way to remediate the injury of voting in an unconstitutionally drawn district. That is similar to abatement of a public nuisance or, for example, in the school desegregation cases, where remediating the injury to the plaintiff before the court necessarily has collateral consequences to many others. Certain environmental cases might have a similar thing. For example, you stop the local plant from pouring, water pollution into the water. That benefits the plaintiff. It happens to benefit a bunch of other people. Now, that's very different than what we have in these universal injunctions, where it is a divisible remedy. I mean, I point to the holding of the District of Massachusetts in this case, looking at the individual plaintiffs. That court said, well, obviously, I don't have to give a universal injunction to protect individuals other than the individual plaintiffs. They are given complete relief by an injunction that tells federal officials only to treat their children as citizens.
I guess the question is why does the law require that? I mean, I appreciate that a court could, in a divisible remedy kind of case, narrow in to the plaintiff, but you seem to be suggesting that Article 3 or Rule 23 or something requires that. And I guess I don't really understand it.
If I may offer two responses to that. In the Article 3 context, that is the principle announced in Worth against Selden, announced in Gill against Whitford, and Lewis against Casey, where this court has said again and again, what we do in the Article 3 context is grant remedy that is tailored to, grant remedies that are tailored to remove the injury to the complaining plaintiff. Sometimes they have even very broad collateral consequences. But in the Article 3 context, what the court has not done, and every time it's focused on this in National Treasuries Union, Employees Union, in the
But I guess I don't see why then the divisible remedies or indivisible remedies is an argument. I mean, if Article 3 is suggesting that the court has to focus in on the plaintiff only, then it would seem to me that that would be the power requirement across the board. I thought Article 3 was really about limiting the court's power with respect to jurisdiction, that we say the court has to determine whether or not there's subject matter jurisdiction over the issue and whether or not there's personal jurisdiction over the defendant. And once you have those things, the court can evaluate the merits of the legal issue and issue, especially in equity, appropriate relief. Now, I appreciate that there are some prudential concerns that the court considers, but it seems to me that in many, many, many circumstances, we have not required the court to limit their relief to the particular plaintiff as a matter of constitutional Article 3 requirement.
I disagree with that. I'd offer a response both first as to Article 3 and then as to the scope of equitable authority. In the Article 3 context, this court said in Worth against Selden, for example, that the Article 3 judicial power exists only to redress the injury to the complaining parties. Again, in Gill against Whitford and Lewis against Casey.
All right, so let me give you a hypothetical. So suppose we have a manufacturing plant that unlawfully releases environmental toxins into the air, and we have a plaintiff who lives near the plant, brings a nuisance lawsuit and says they're being harmed by unlawful release. Your argument suggests that the judgment for the plaintiff has to narrow in on preventing, to the extent possible, preventing harm to the plaintiff. But it seems to me that that's not necessarily the case. You suggest with the Chief Justice in response to him that there can be incidental beneficiaries, that the court could say no more toxins if it's unlawful for the defendant to do that, correct?
Yes, we do.
So why, if your Article 3 principle is correct?
Because again, the Article 3 principle is remedying the injury to the plaintiff, or set of plaintiffs, could be many, who are before the court.
Right.
That has collateral consequences,
Counsel,
that could help.
Let me ask you on that point, would one distinction be who's bound by the judgment? Like, I'm wondering whether if the plaintiff needs, you can only, I think Judge Strauss said in the Eighth Circuit when addressing this issue, you can't peel off part of a nuisance, so the whole thing has to be shut down. Could a neighbor sue affirmatively to hold the nuisance maker in contempt if he started to begin again the nuisance?
That's a great point. It would not be bounding on those collaterally benefited parties, so to speak. I don't want to call them parties because they're not parties before the court. And that, of course, highlights one of the deep problems with the universal.
But why
could you do that?
Answer, though?
Could you do that now for the universal injunction? Could a plaintiff, for example, who has the protection of the universal injunction but was not named in the suit, bring a contempt action of the sort I just described? They
could not do that, but what they could do is run to any of 93 other judicial districts and bring their own lawsuit if they.
No. Under the injunction as it stands, under the injunctions as they stand, could a non-named plaintiff who has the benefit of the universal injunction that's currently in place, could that plaintiff bring a contempt proceeding?
We would.
Or I guess I shouldn't call them a plaintiff. Could that non-party?
We would dispute that they would have the standing to do that because it goes to the heart of.
Well, no. Let's see. Maybe I'm not being clear. Assume the universal injunction is good. Like, drop your argument right now.
Oh, I see. Yeah.
As they currently stand, could someone who is not named in the suit but a beneficiary bring a contempt proceeding?
I think that is what the respondents would certainly contend.
Do you concede that the plaintiffs could bring a Rule 23, like the individual plaintiffs?
We would dispute. I mean, we'd have to address the Rule 23 issues, kind of all the criteria as they came up.
But they could seek it. Okay, and then last question.
And they have done that in the Western District of Washington. It's just never been briefed because they
Okay, just last question on this point. The states have a different kind of claim for financial harm, and they've pointed out that it would be very difficult to remedy that without some sort of broader relief. I know you contest their standing. I want you to assume that I think they have standing. Why wouldn't they be entitled to an injunction of the scope of the one that has currently been entered?
I would say two reasons. First of all, it's not necessary to provide complete relief to the plaintiffs. What we offered, for example, in the District of Massachusetts in the First Circuit was an injunction that would enjoin the federal officials and order them to treat the people who would otherwise be covered by the executive order as eligible for the services that result in the pocketbook injuries to the states. And there's really no response to that. That is obviously would fully remediate their injuries and does not require the injunction to be applied in all other 50 states. One state comes in and says, well, people are going to move across state lines. Therefore, we've got 21 states in this case who don't want this relief. Sorry, you've got to impose it on everybody because it has to be offered to this one particular state. So that's one response. The other response is this notion that the states have to be provided a complete relief because of interstate travel and patchwork. I think that's very effectively responded to by Chief Judge Sutton's opinion in the Second Circuit, where he says, this is a problem. If we adopt this logic, it justifies a universal injunction in every single case, and that can't be the case. The Fifth Circuit's recent DACA decision comes to the same conclusion.
What do you say, though, to the suggestion, General, that in this particular case, those patchwork problems for, frankly, the government, as well as for plaintiffs, justify broader relief?
As to the government, again, Chief Judge Sutton addressed that directly as well when he said that's the federal government's problem. In other words, the federal government, for example, in the First Circuit, we offered that as a narrower scope of injunction, and the decision was, well, that would cause you too many administrative problems. And I think Chief Judge Sutton directly addresses that when he says that's a problem for the executive branch in the first instance.
All right.
Yeah.
And then with respect to class certification, your friends on the other side point out that that takes time. And there are, as you've emphasized, hurdles that have to be met to achieve class certification. And the argument, of course, is that the injury is immediate and ongoing, and as Justice Sotomayor suggested, might be seriously questioned as to its compliance with this court's precedents. Your thoughts?
I would offer a couple of things in response to that. First of all, there are tools for the courts have tools to achieve sort of class-wide universal relief. I referred earlier there, we found 4 recent district court decisions where class-wide relief was given a kind of an emergency basis. However, more fundamentally than that.
And you agree that that's appropriate in certain cases?
It may be appropriate. We do not concede that it's appropriate in this case, but it may be appropriate in other cases. Certainly it's an equitable tool that is consistent with, for example, the grant of equitable authority in the 1789 Judiciary Act, as this court interpreted in the Grupo Mexicano decision, and honestly a line of decisions going all the way back to the early 19th century. So there are tools to address emergency situations, but more fundamentally than that, it is a feature, not a bug, of Article 3 that courts grant relief to the people who sue in front of them.
Yes.
So the notion that relief has to be given to the whole world because others who have not taken the time to sue are not before the courts is something that results in all these problems.
Last question. Do we need to reach the Article 3 question? I mean, wouldn't it be wise, even if you were to prevail, for the court to reserve that question rather than decide that Congress, for example, could never endow this court with that authority?
That's exactly correct. The court does not have to rest on Article 3 because the court could say, and as we've argued and as Justice Thomas' separate opinion in Trump against Hawaii says, the 1789 Judiciary Act, when it said suits in equity are what the federal courts can do, we had nothing like this in mind. And then I point to the language in Grupo Mexicano where the court said there what was at issue was a preliminary injunction that froze a likely insolvent debtor's assets so that the plaintiff could collect at the end of the case. And the court said that's a nuclear weapon in the law, and we're not that had no analog in 1789 in the practices of the Court of Chancery. And if that's a nuclear weapon, I don't know what this is, where repeatedly 40 times in this administration we're being enjoined against the entire world.
I'm just going to ask you to put yourself in a different frame of mind. Hard to do. Assume something you won't want to assume. But the assumption that I want you to make is that on the merits, which of course you did not take to this court, on the merits you are wrong, that the EO is unlawful. And I want to ask you, if we assume that, how do we get to that result on your view of the rules?
A weird question.
It is very difficult for me to attempt the hypothetical, but I will.
I think that that's the important question in this case. Let's just assume you're dead wrong. How do we get to that result?
No.
Does every single person
that
is affected
question.
by this EO have to bring their own suit? Are there alternatives? How long does it take? How do we get to the result that there is a single rule of citizenship that is the rule that we've historically applied rather than the rule that the EO would have us do?
Rule 23 would be one natural path, assuming that a class could be certified, which we might dispute in this particular case.
Well, you might dispute it, and I think the question is there a class that's just all children of people who have entered illegally? Is that an appropriate class? Can the same thing be done under Rule 23? Or are you going to tell me that, no, Rule 23 has lots of requirements and you'll never be able to certify a class like that?
Rule 23 provides the equitable tools subject to rigorous criteria, appropriately rigorous criteria, to obtain that kind of class-wide and
that suggests to me you're going to be standing up here in the next case saying that Rule 23 is inapt for this circumstance, with this number of people, maybe with some questions that are individual, who knows. So let's put Rule 23 aside, because I got to tell you, that does not fill me with great confidence. How else are we going to get to the right result here, which is on my assumption that the EO is illegal?
That would be a profoundly wrong result, but I think what I would offer is that, very similar to Labrador against Poe, what the court should be engaging here is a balancing of the equitable factors as to the scope of remedial relief, not as to the underlying merits. And our contention that this exceeds the traditional scope of equity that's reflected in the 1789 Judiciary Act, we're overwhelmingly likely to succeed on those merits for all the reasons that are stated in our briefs.
I mean, that's a lot of words, and I don't have an answer for if one thinks. And, look, there are all kinds of abuses of nationwide injunctions.
Yes.
But I think that the question that this case presents is that if one thinks that it's quite clear that the EO is illegal, how does one get to that result, in what time frame, on your set of rules, without the possibility of a nationwide injunction?
On this case and on many similar cases, the appropriate way to do it is for there to be multiple lower courts considering it, the appropriate percolation that flows through the lower courts, and then ultimately this court decides the merits in a nationwide binding precedent. You have a complete inversion of that through the nationwide injunctions where the district
So, General Sauer, are you really going to answer Justice Kagan by saying there's no way to do this expeditiously?
Well, I'll refer to my former answers. Rule 23 provides the tools to do so, multiple injunctions.
But you resisted Justice Kagan when she said, could the individual plaintiffs form a class?
That has never been briefed in the court below. I do not concede that we wouldn't oppose class certification in this particular case. There may be arguments that this case is or is not appropriate for class certification. And
if there were a class appropriate for class certification, you concede that could resolve the question quickly?
Yes, absolutely.
You concede it could resolve the question quickly through precedent?
Yes, absolutely. It could do so. I mean, we obviously dispute the...
So just on that point...
And if the court... Sorry to interrupt. Go ahead, please.
What a gentleman.
I got a quick one.
Well, I'm just going to say just on that point. So, let's say that we're an individual person even. Let's say it wasn't a class. And goes up and gets a ruling from the Second Circuit that the EO is illegal. Does the government commit to not applying its EO in the entire Second Circuit? Or does it say, no, we can continue to apply the rule as to everybody else in the Second Circuit?
I can't say as to this individual case. Generally, our practice is to respect circuit precedent within the circuit, but there are exceptions to that.
Yes, that is generally your practice, and I'm asking whether it would be your practice in this case.
I can't answer because it would depend on what the lower court decision said. So there are circumstances, as I was suggesting, where we think that we want to continue to litigate that in other district courts in the same circuit as well.
Yeah, so that means it's not even the normal time it takes for everything to get up, through the circuit courts and to the Supreme Court. Because even in those circuits that say that the EO is illegal, you're going to be saying, no, we only commit to saying it's illegal to this one guy who brought the suit.
Article 3 and the court's traditional equitable practices
That's
provide
the law.
a range of tools to address that, including a potentially nationwide class action, not a nationwide
A
universal
nationwide
injunction is
class
not one of
action,
those
which
tools.
you say you're going to oppose when that gets challenged.
Because it's not
We're
a
likely to
class.
oppose
When
on
that
the merits.
Proposed.
Yes, and if it does not meet the rigorous criteria of class
Obviously.
certification, the court should not enter that injunctive
Obviously.
relief. That's
Do you think, like,
feature, not a
suppose,
bug.
how about you're not willing to commit to abiding by the Second Circuit's precedent suppose that there's a single person who brings a suit, and it gets all the way up to us after 3 or 4 or 5 years. And we say, we really do agree with those 4 precedents that Justice Sotomayor started with, and your EO is illegal. Is that only going to bind the one guy who brought this suit?
No, that
the
would be a
Supreme
nationwide
Court.
precedent that
Yes.
the government would respect.
So finally, once it gets to us after 4 years, you're going to respect that.
Yes, and in
Yeah,
addition,
it's
we
the
may
Supreme
well
Court.
respect circuit-wide precedent. The
for-
Second Circuit, it just is.
And for 4 years, there are going to be like an untold number of people who, according to all the law that this court has ever made, ought to be citizens who are not being treated as such.
And in the meantime, any of those plaintiffs could have come forward and sought, preliminary injunctive relief, and they could do so on a class-wide basis. There are tools to address this, but the universal injunction, which is issued here 3 days after the executive order was issued, is not one of those tools.
Thank you, counsel. 3 years, 4 years, we've been able to move much more expeditiously. I think we did the TikTok case in a month. Presuming, I gather an important part of your answer is that people can litigate differently, and one will go to Massachusetts, the other one will go to Houston, and you'll get conflicting decisions fairly quickly. And is there any reason why this court, and I gather that's your safety net, is that at the end of the day, however long the day is, this court can issue a decision and it will bind everything else. Is there any reason in this particular litigation that we would be unable to act expeditiously?
Absolutely not, Mr. Chief Justice.
Okay, thank you. Justice Thomas?
Thank you.
General, when were the first universal injunctions used?
We believe that the best reading of that is what you said in Trump against Hawaii, which is that Wirtz in 1963 was really the first universal injunction. There's a dispute about Perkins against Lucas Oil going back to 1940. And of course, we point to the court's opinion that reversed that universal injunction issued by the D.C. Circuit and said it's profoundly wrong. Now, if you look at the cases that the either party cite, you see a common theme. The cases that we cite, like National Treasury's Employment Union, Perkins against Lucas Oil, Frothingham in Massachusetts against Mellon, going back to Scott against Donald, and all of those are cases where the court considered and addressed the sort of universal, in that case, statewide issue of provision of injunctive relief. So when the court has considered and addressed this, it has consistently said you have to limit the remedy to the plaintiffs who are appearing in court and complaining of that remedy.
So we survived until the 1960s without universal injunction.
Yeah, that's right.
That's exactly correct. And in fact, those were very limited, very rare, even in the 1960s. It really exploded in 2007 in our cert petition in Summers against Earth Island Institute. We pointed out that the Ninth Circuit had started doing this in a whole bunch of cases involving environmental claims.
Justice Alito?
You began by outlining what you see as the practical problems that have been created by universal injunctions. If we were to hold that the states have standing, and if it is possible for a plaintiff to get emergency certification of a class, suppose we agreed with you on universal injunctions, but allowed those other 2 avenues, would the practical problem be rectified to any substantial degree?
Certainly, if there were an injunction that extended to all of the litigating states, that would cover a very substantial portion of the country, and also an emergency sort of class certification decision might also grant very broad relief.
So the answer is that the practical problem would not be solved. And if that's the case, what is the point of this argument about universal injunctions?
I think the point is that universal injunctions exceed constitutional principles of Article 3, and they exceed the traditional equitable authority. And that's what yields all these sort of pathologies, so to speak, of the current practice of issuing them very, very easily.
Thank you.
Justice Sotomayor?
You answered Justice Gorsuch, I think correctly, that if Article 3 precludes universal injunctions, then even class actions are illegal. That's what you're arguing, isn't it?
I disagree with that profoundly.
How could it, if Article 3 and only prohibits injunctions that affect non-members or non-plaintiffs, how could Congress give a remedy like a class action?
In an article, or in a Rule 23 class, every member, represented member of the class, has standing by hypothesis. So every single one of them has an Article 3 injury, and Rule 23 again.
So that would be the only method.
It would be very similar to the Bill of Peace, where all those parties, either their president or representative capacity, are bound.
We can act quickly. If we are worried about those thousands of children who are going to be born without citizenship papers that could render them stateless in some places because some of their parents' homes don't recognize
all about the kids.
Children of their nationals unless those children are born in their countries. They're not going to be receiving federal benefits because that's the claim of the plaintiffs here, that of the state plaintiffs, that they're not going to be able to provide services to those children.
All about the babies.
Shouldn't we grant
illegal
cert before
babies.
Judgment on that issue? If we're afraid that this is, or even have a thought that this is unlawful executive action, that it is Congress who decides citizenship, not the executive, if we believe, some of us were to believe that, why should we permit those countless others to be subject to what we think is an unlawful executive action? As unlawful as an executive taking the guns away from every citizen.
If you're the Supreme Court.
Cert before judgment would be another tool, but through which this court could act expeditiously.
Is this the kind of case where the equities would call for that? And why wouldn't it? It's a pure legal question. What does the Constitution mean with respect to citizenship? There are no individual facts that would alter our conclusion. If we can't do it by a universal injunction, because you say Article 3 doesn't permit that, Article 3 wouldn't permit us to give a universal injunction, even if we rule. Why don't we grant cert before judgment, so that all of these parents would have a firm Supreme Court decision that they can take where? Because you're saying nobody can grant a universal
That Xanax
injunction.
might be hitting
No
right now.
party has asked for that in this case, and I think one reason is that would deny the court of the benefit of percolation in multiple lower courts of a novel and sensitive and important constitutional question.
We have novel courts who've percolated this issue and said, you're violating precedent. Not only precedent, but the plain meaning of the 14th of the Constitution.
Respectfully, I think what we have are lower courts making snap judgments on the merits that ignore the fundamental principle of the 14th Amendment, that it was about giving citizenship to the children of slaves, not to the children of illegal immigrants who really were not even a very discrete class at that time. And that's the sort of argument that deserves percolation.
There were some people in Congress who argued against the 13th Amendment just because of that. Some people who argued against passing the amendment just because of that, because it would give citizenship to gypsies.
I think the relevant history of the 14th Amendment is the statements of Senator Trumbull, who emphasized that domicile was the key criterion. He said that in a letter to Andrew Jackson, and we've cited in our Ninth Circuit briefing a host of decisions that back that up.
It got rejected repeatedly. We can go into the history of citizenship, but I still go back to my question. You claim that there is absolutely no constitutional way to stop, put this aside, to stop a president from an unconstitutional act, a clearly, indisputably unconstitutional act, taking every gun from every citizen. We couldn't stop that.
I disagree with that for the reasons I've said, including the equitable tools.
No, because you said to us we'd have to wait until there was a final judgment. You're not sure you would respect the judgment of every circuit. You're not sure that you would respect even a final judgment of the Supreme Court, because it only binds the parties before it. And if there's no class action, that only binds the parties before the court.
I don't think there's a, so to speak, really, really unconstitutional exception to the strictures of Article 3 or the scope of equitable authority, and the court should not recognize one, because what we see, not just in this case, but in the 39 others, is that the district courts who are issued these injunctions all passionately disagree with the thing that's being challenged in that. So that principle that, well, this we think is really unconstitutional, therefore we should ignore the general principles of Article 3 is not a principle the court ought to adopt.
You don't have that power. You can't do that.
Justice Kagan?
So, General, on this question of expedition, I mean, it sort of depends on the government's own actions in a case like this one,
it's Kagan again,
where one can expect that there is not going to be a great deal of disagreement among the lower courts. I mean, let's assume that you lose in the lower courts pretty uniformly, as you have been losing on this issue, and that you never take this question to us. I mean, I noticed that you didn't take the substantive question to us. You only took the nationwide injunction question to us. I mean, why would you take the substantive question to us? You're losing a bunch of cases, this guy over here, this woman over here, you know, they'll have to be treated as citizens, but nobody else will. Why would you ever take this case to us?
Well, in this particular case, we have deliberately not presented the merits to this court on the question of the scope of remedies, because, of course, that makes it a clean vehicle where the court doesn't have to look at the past.
You're ignoring the import of my question. I'm suggesting that in a case in which the government is losing constantly, there's nobody else who's going to appeal, they're winning, it's up to you to decide whether to take this case to us. If I were in your shoes, there is no way I'd approach the Supreme Court with this case. So you just keep on losing in the lower courts. And what's supposed to happen to prevent that?
Again, I respectfully disagree with that forecast of the merits, but in response to the question, what I would say is we have an adversarial system, and if the government is not, for example, not respecting circuit precedent on the court's hypothetical in the Second Circuit, someone injured in the Second Circuit could take the case up, and they could say, look, the government is violating circuit precedent on the hypothetical multiple circuits.
That's the case we're going to take? Somebody who says, you know, after we've said that this all has to be done one by one by one, then we're going to take a case from somebody who objects to proceeding one by one by one?
I'm not sure I understand the question. I understood the hypothetical.
If you win this challenge and say there is no nationwide injunction and it all has to be through individual cases, then I can't see how an individual who is not, you know, being treated equivalently to the individual who brought the case would have any ability to bring the substantive question to us.
They would bring a lawsuit in the federal district courts against the government for an injunction protecting them. And if the government wasn't respecting, you know, on the hypothetical circuit precedent.
And then they win. And again, I mean, you need somebody to lose. But nobody's going to lose in this case. It's just you're going to have, like, individual by individual by individual, and all of those individuals are going to win, and the ones who can't afford to go to court, they're the ones who are going to lose.
The tools that are provided to address hypotheticals like this, again,
This is not a hypothetical. This is happening out there, right? Every court has ruled against you.
We've only had snap judgments on the merits. You know, obviously, we're fully briefing the merits in the courts of appeals, and our arguments are compelling. More fundamentally, in response to the question.
I'm suggesting to you, like, the real brunt of my question is, in a case like this, the government has no incentive to bring this case to the Supreme Court because it's not really losing anything. It's losing a lot of individual cases which still allow it to enforce its EO against the vast majority of people to whom it applies.
And again, Rule 23 provides an avenue to address those very concerns.
Thank you.
And they can take it up to SCOTUS.
Mr. Gorsuch?
SCOTUS can issue precedent.
Justice Kagan asked my questions better than I could have. How do you suggest we reach this case on the merits expeditiously?
There's a number of tools the court could do that. We think this case is one that cries out for percolation, that the court should allow the lower courts to address the merits issue multiple times. It's currently on briefing in 3 different cases in the First, Fourth, and Ninth Circuits, and we think that that's the appropriate way to do it. If the court disagreed, obviously,
when you lose one of those, do you intend to seek cert?
If we lose, yes, absolutely.
Justice Kavanaugh?
So the technical problem here seems to be class-wide relief without the district courts going through the steps to assess whether a class should be certified.
Yep.
Correct?
Correct.
Okay. And if you win here on this procedural point, it seems very likely that the day after, there are going to be suits filed all over the place seeking class-wide treatment, maybe statewide classes, circuit-wide classes, maybe nationwide classes. I'm sure they're being prepared now, right? And
gangbang lawyers.
On what basis would you oppose a statewide class?
I could imagine certain bases, and again, we haven't briefed this in the lower courts yet.
You've been promising everyone here that Rule 23 is the cure-all. And I want to explore on what basis you would oppose a statewide class. Just take that one for now.
For example, and again, this is very hypothetical because I'm not predicting that we will or will not oppose that. We haven't taken a position on that yet.
If you were to oppose it, on what basis would you plausibly oppose it?
There may be problems of commonality and typicality, for example. For example, there's 2 different sets of groups that are affected by the executive order. There are those where the mothers are temporarily present and those where the mother are illegally present. And in both cases, the father is neither a citizen nor a lawful permanent resident. So there might be issues of typicality. Adequacy of representation might very well be an issue. So there would have to be that rigorous application of those criteria. Now, the argument may be this is a case that is a natural candidate for a Rule 23b2 certification. That may well be true. The government hasn't taken a position on that. Our position is not that class certification will necessarily be granted. Our position is that Rule 23 is how these sorts of claims should be channeled.
And you think, I think you just said, it's very possible that class certification may be granted.
It is possible. We don't know yet because there was a class certification motion filed at the very beginning in the Western District of Washington, and it was just never briefed because obviously the pathology here is that the nationwide injunctions just go blowing past the class certification procedures.
And I guess Rule 23b2, for a lot of the cases we've had over the past 25 years that you talk about where there have been universal injunctions or where the lower courts have had that, I mean, 23b2 could have been used in a lot of those, presumably, correct? Eviction moratorium, student loans, OSHA vaccine mandate. Do you see the possibility that 23b2 could have been used instead of, I mean, some of those were APA, but put aside the APA issue for now.
Yeah, we do set aside that issue, if I may.
I got it.
But yes, I agree with that as to some, but none of the other cases. It's hard to see how, for example, Biden against Nebraska, where a state was the plaintiff, might have been a 23b2 class. And the Alabama Association of Realtors might have been a much better candidate for that. And again, not taking a position on the individual merits, our overarching point is there's a tradition of equity in this country that goes back to the English Court of Chancery, and what's happening in these universal injunctions, again, 40 times in this administration, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding those appropriate procedures to seek this kind of, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding those appropriate procedures to seek this kind of, at least 22 times in the last administration, 64 times in the administration before that, is just disregarding
anyone, party or not, in light of stare decisis.
Sorry about that.
End quote. You agree with that?
Yes, we do.
Okay. If you prevail here, the original executive order had a 30-day period before it took effect. If you prevail here, should there be any pause so that things can happen that need to happen for 30 days or some period of time, or should we not even worry about that?
Yes, we can see that the 30-day ramp-up period that the executive order itself calls for never started because the universal TROs were entered almost immediately, and we don't dispute that there should be a 30-day ramp-up period. for another reason as well, which is that we've been enjoined from even doing guidance, even formulating a policy, and that itself is another problem with these injunctions.
On the day after it goes into effect, this is just a very practical question how this is going to work. What do hospitals do with a newborn? What do states do with a newborn?
I don't think they do anything different. What the executive order says in Section 2 is that federal officials do not accept documents that have the wrong designation of citizenship from people who are subject to the executive order.
How are they going to know that?
The states can continue to, the federal officials will have to figure that out, essentially.
How?
So you could imagine a number of ways that the federal officials could.
Such as
they could require a showing of, documentation showing legal presence in the country. For a temporary visitor, for example, they could see whether they're on a B-1 visa, which would exclude kind of the birthright citizenship in that context.
For all the newborns? Is that how that's going to work?
Again, we don't know because the agencies were never given the opportunity to formulate the guidance. They would have 30
They're only
days.
going to have 30 days to do this. You think they can get it together in time?
They're under, that's what the executive order instructs them to do, and hopefully they will do so. Again, it's a speculative and hypothetical scenario because they were enjoined from even starting that process.
And then last question. You mentioned before this has come up in the last 4 or 5 administrations primarily. I guess I've thought about that a lot too. Why? It seems why might be it's harder to get legislation through Congress, particularly with the filibuster rule. Presidents want to get things done with good intentions. The executive branches that work for those presidents push hard to, when they can't get new authority, to stretch or use existing authority. And they've been pushing. Understandably, all with good intentions, all the presidents, both parties, right, with good intentions pushing. Is that your understanding of why this has happened more, that there's less ability to get legislation? Because I'm trying to figure out the why to your opening about the last 4 or 5 administrations. I agree with it. I think that might be the why, but I'm curious what you think.
I'm speculating about the motivations of the individual district judges who grant these, but one explanation might be this is an extraordinary power. It's a very strong power for the reasons the questions have reflected.
Well,
for a district
let me
judge
just pause you right there. The underlying point is that these district judges are not just doing universal injunctions. They're finding these actions illegal because they're exceeding existing authority, and oftentimes we are too. When it gets to us, finding the actions of presidents of both parties unlawful because they exceed existing authority. So is that coming up more often why is that coming up more often?
It's hard to do an historical analysis, but I would draw an analogy to the New Deal. And Professor Bray makes this point in his article that actually there were very, very passionate challenges to sort of nationwide policies during the Roosevelt administration, and they were not addressed by issuing universal injunctions. He cites an example where in one case, a policy had been held illegal, and there were like 1,600 injunctions against that policy, all protecting the individual plaintiffs. So if you look at the history, it's not clear that what we have of disagreement, but difficulty, gridlock, getting things through Congress and so forth, that's not necessarily new. What is new, and is certainly unique to the last 5 presidential administrations, is having these given on this widespread basis and this systematic basis, 40 again in the last 4 months.
Thank you.
Justice Barrett?
General Sauer, I want to ask you about a potential tension. Well, no, not potential tension, an actual tension that I see in answers that you gave to Justice Kavanaugh and Justice Kagan. You resisted Justice Kagan when she asked you whether the government would obey within the Second Circuit a precedent. I'm distinguishing between opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And certain some examples might be a situation where we're litigating to try and get that circuit precedent overruled. And
they're not the Supreme Court.
Okay, so I'm not talking about a situation in which, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, long-standing policy of the federal government to take that approach?
That is my understanding.
Okay, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay. Next question. So this is also a follow-up to some of the questions that others have asked you about the merits of the order not being before us. Did I understand your answer to be because you think percolation is really important for this one?
We do think percolation is really important for this one, but the reason the merits are not before is because we've only submitted a stay application on the scope of relief question, and as Labrador against Poe indicates, the scope of relief is a separate question for the merits.
I understand it's a separate question, but there are plenty of times that the government comes to us and asks for both.
Absolutely. For example, recently in the Wilkins and Cox application, we did exactly that.
And the reason why you didn't ask for both here is because you think that the merits question needs percolation.
Yes, but also more fundamentally, it illustrates that the very problem with these nationwide injunctions is they force this rushed, fast and furious decisions on the merits. So I think it'd be very inappropriate in this case to come to a stay application saying, please give us a rushed, decision on the merits of something that's very complex.
But the government's done that in other cases too, right?
Those cases would be different. In this case, the example I gave earlier, we think it's very clear cut on the merits. This one is, we concede a novel and sensitive
So this one
question.
isn't clear cut on the merits?
This one, in this case, we want the court to address the remedial issue. If we offer the merit first, that's a vehicle problem because the court has, in many cases, just addressed the merits and not the remedial issue. And it's imperative from the federal government's perspective that the remedial question be addressed.
Okay, so last question is about why that is. Justice Alito asked you, well, what's the point of this? If the same thing could happen, which is effectively the EO being enjoined everywhere via class action or because it's necessary to provide complete relief, say, to the states, is there any difference in your view between, say, a class is certified of all individual plaintiffs and they win, and the executive order class-wide, there's a judgment saying that it can't be enforced? Do you want to say, follow up, is there any practical distinction you see? Why does the government care? Is it just the rigors of the certification process, or is it something more?
The rigors of the certification process. Keep in mind that in many of these cases, we successfully oppose class action.
Let's assume I think you can't successfully oppose it here for individual plaintiffs.
Well, that opportunity to have our day in court on that is very, very important.
I understand, but let's assume, with my assumption.
Assuming that we were to lose in
assume the class is certified. Is there any benefit? If a class is certified, and let's say, you were pointing out that the executive order targets two different kinds of people. Let's assume that it's commonality because, they only target one portion of the order, right? In that circumstance, does the government get anything different? This is back to Justice Alito's question about what's it to you? What's the practical difference to you? Do you want to say anything about whether there's a practical difference between a universal injunction and a loss in the class?
Absolutely. Okay. Among many others, the represented class members are bound in the class action context. And that means that if they lose, they're bound by that as well. So they're taking a grave risk, so to speak, by proceeding through a class action. And it has this symmetry where the government is bound if we lose, they are bound if we don't lose. And that's a very, very important distinction.
And you would respect that judgment?
If it were a judgment. Now we may try to litigate in other contexts to try and get a different judgment from a different district court, but we would be bound by that judgment, as would they. And that's the crucial point.
Okay.
Justice Jackson?
No. So as far as I can tell, your bottom line seems to be that what you call universal injunctions give relief to non-parties without going through the necessary steps, which you identify in Rule 23. Do I have that right? I mean, is that sort of like boiled to bare essence what you're saying?
I would say there's a lot more to it, but that's one very important point.
That's a key point that I want to focus in on for a moment. I guess I don't understand why you are saying that these kinds of injunctions are giving relief to non-parties. First of all, I think they can be also easily characterized as focusing only on the defendant pursuant to the court's jurisdiction, personal jurisdiction over this person relative to the subject matter jurisdiction that the court has, and the relief is telling the defendant, stop doing this thing that the court has found to be unlawful. So rather than characterizing it as a quote-unquote universal injunction, I think one could easily see that this is just about the extent to which the court can constrain a defendant over whom it has personal jurisdiction. Can it do so completely or just partially with respect to, just say stop with respect to this plaintiff? Am I I don't understand where this idea of universal injunctions comes from.
Just change the label, basically.
I think the relevant distinction is an order that orders, in this case, the government defendant to cease allegedly unlawful activity as to the parties who have come into court and sued, and one that says to the government defendant, cease the allegedly lawful activity against everyone in the entire world.
No, just cease it. Just stop. This thing, this executive order, I mean, we do this in the APA context all the time, right? The statute says you hold that you set aside the conduct, right? That it's unlawful. And we don't really parse it out and say, okay, but it's unlawful only as it applies to the plaintiff or not. So it's a very common concept for the court to enjoin a defendant from doing particular unlawful behavior. And what you're now asking us to do is to require that the court have an additional limitation in its order that says you only have to stop doing this with respect to the plaintiff. And that's the part that I don't understand. I guess, from what I can read from your papers and what you've said here, that limitation, you say, comes from this principle that if you don't do that, you would be somehow giving relief to non-parties. But I wonder if that's right. I mean, it seems to me that the relief is the judgment that you provide to the plaintiff that says, stop doing this conduct. And you give it only to the plaintiff. That's where the limitation comes. The plaintiff is the only person who can go to court after you violate this order and enforce it. Other people are incidental beneficiaries of a court ordering you to follow the law. I mean, that's like everyone in the world. When the court says, follow the law, anybody who would have been hurt by your not following the law benefits. Okay. I don't understand why that would limit the court in its ability to tell you, don't do this unlawful conduct.
Two responses to that.
Yes.
There's a lot there. Two responses to that.
Yeah,
one is that principle that your question referred to is the holding of the court in Worth against Selden, and it's reaffirmed in Gill against Whitford, in Lewis against Casey, and similar cases, that the authority of the federal court, whether it's viewed as arising under Article 3 or under its traditional scope of equitable authority, is to remediate the injuries to the complaining party. And then to address your question about...
Can I just stop you there? I'm, as the court, remediating the injury by telling the defendant to stop doing this behavior. The plaintiff has brought a claim that this executive order is unlawful. I look at it, I litigate it, and I say, you're right. Stop doing it. You cannot enforce this order. So I don't understand why that's like outside the scope of Worth versus Selden.
If the court in that case is imposing what we've called an indivisible remedy, for example, vacator under the APA, there's a debate about what set aside means. Assuming it means to vacate, then the remedy that Congress has provided as a condition of its delegation to the agency is if one part of the, if the regulation is unlawful, then the remedy granted, which directly remediates the plaintiff's injury on that hypothetical, is an indivisible remedy that benefits others. Here in this case, and in all the other 40 cases, we see something totally different.
Yeah, I understand.
It's not necessary to remediate the injuries of the plaintiff before them. That is the
I understand. Let me just turn your attention to one other thing. Because the real concern, I think, is that your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. Justice Kagan says, let's assume, for the purpose of this, that you're wrong about the merits, that the government is not allowed to do this under the Constitution, and yet it seems to me that your argument says we get to keep on doing it until everyone who is potentially harmed by it figures out how to file a lawsuit, hire a lawyer, et cetera.
Or SCOTUS just
I don't
settles
understand how that is remotely consistent with the rule of law.
It's like they forget they're on the Supreme Court.
And I appreciate that you go back to English common law and the Chancery Court, but they had a different system.
So dramatic.
The fact that courts back in English Chancery couldn't enjoin the king, I think, is not analogous or indicative of what courts can do in our system, where the king, quote unquote, the executive, is supposed to be bound by the law. And the court has the power to say what the law is. And so one would think that the court could say, this conduct is unlawful and you have to stop doing it.
I think the catch-me-if-you-can problem operates in the opposite direction, where we have the government racing from jurisdiction to jurisdiction, having to sort of clear the table in order to implement a new policy. A great example of this is in the Schilling litigation, where the military had a military readiness policy. It was universally enjoined by the DDC. It went up to the DC Circuit. The DC Circuit stayed that injunction to allow that policy to go into effect, and then 1 hour later, a district court on the other side of the country universally.
Can I just ask you one final thing, because this relates to also something that Justice Kagan said?
Yes, last question.
I would think we'd want the system to move as quickly as possible to reach the merits of the issue, and maybe have this court decide whether or not the government is entitled to do this under the law. Wouldn't having universal injunctions actually facilitate that? It seems to me that when the government is completely enjoined from doing the thing it wants to do, it moves quickly to appeal that, to get it to the Supreme Court, and that's actually what we would want. What I worry about is similar to what Justice Kagan points out, is that if the government is saying no lower court can completely enjoin it, it actually means that the government just keeps on doing the purportedly unlawful thing, and it delays the ability for this court to reach the underlying issue.
Percolation of novel, sensitive constitutional issues is a merit of our system. It is not a bad feature of the system.
Thank you.
Thank you, counsel.
Gosh. All right, so that was a little rough, to be honest with you.
Mr. Feigenbaum?
Mr. Chief Justice, and may it please the court. This court should deny the emergency application because this injunction was properly designed to ensure that the states would get relief for our own Article III injuries, as we suffer significant pocketbook and sovereign harms from implementation of this executive order, including from the application of this EO to the 6,000 babies born to New Jersey parents out of state every year. The U.S. prefers alternative approaches for granting that relief, alternatives it never raised in the district court below. But its approach would require citizenship to vary based on the state in which you're born, or even turn on or off when someone crosses state lines, raising serious and unanswered administrability questions, not just for the federal government, but also for the states. And it would offend the text and history of the Citizenship Clause itself. Since the 14th Amendment, our country has never allowed American citizenship to vary based on the state in which someone resides, because the post-Civil War nation wrote into our Constitution that citizens of the United States and of the states would be one and the same without variation across state lines. The U.S. has claimed that Article III establishes a bright-line rule barring such injunctions no matter the circumstance, even where the states do need it to meet their own harms, finds no support in this court's cases or in the history of equity. Its argument that a single district court cannot decide birthright citizenship or that we need more percolation on that question for the nation overlooks that this court already settled this exact constitutional question 127 years ago, and that this EO is contrary to over a century of executive practice. Finally, the U.S.'s objection that nationwide PIs have simply become too common in the last few months, a complaint about other injunctions sought by other parties, cannot undermine the extraordinary bases for this one. The states, who regularly come before this court as plaintiff and defendant alike, agree that nationwide relief can be reserved for narrow circumstances, but it was needed here. I welcome this court's questions.
Yeah, great. Fabulous job there. Fabulous.
Putting the merits aside, what do you think is the origin of, or at least the pedigree of universal injunctions, particularly the Bill of Peace, if you would discuss that?
Absolutely, Your Honor. So there's two categories of these broad injunctions. So first, although we use the term nationwide injunction, if the nationwide injunction is actually about meeting our harm and the alternatives are not legally or practically workable, then it isn't even a universal injunction, as I know this court's separate writings has used the term, because it's about meeting our own Article III injury, which is our basic submission about this case. But we do agree that there's some space for universal relief. We trace it back through the history from the Bill of Peace, through Equity Rule 48, which specifically clarified that in the American equitable tradition, it was not always the case that universal relief would bind the non-parties, even as it might benefit the non-parties, continuing on to the tax collection injunctions in the 19th century, and then continuing on as recently as this court's order in AARP. So I do think they've always been in narrow circumstances. They've never been the reflexive or norm of how relief should be granted in this country, but they have been available. I don't think I need that for my case, but I do think they're available in narrow circumstances.
You say they should be available only in narrow circumstances. Why is that?
Yeah, so I could offer the three that I think make the most sense, but we're mindful of some of the concerns that the United States raises. We are states who've benefited from federal policies. We are states who have our own statutes and policies. So sometimes we are on the other side of the V in cases involving universal relief. So we are sympathetic to some of the concerns the United States has about percolation, about running the table in particular cases. We just don't think that that supports a bright line rule that says they're never available. And we've identified, I think, at least three circumstances where they would make sense to be available. The first would be in cases where the alternative ways of remedying the harm for the parties are not practically or legally workable. That's this case, and I'll return to that in a second. The second would be congressional authorization. So I took my friend on the other side to try to set aside vacatur, but I do think their Article III objections would raise serious questions for remedies like vacatur, for remedies like the Hobbs Act, even the Hobbs Act, which could set a nationwide PI after a multi-circuit lottery, might ultimately have problems under their view of Article III. And then the third thing I would say is there may be cases in which the alternative forms of getting non-party relief are not legally or practically available. So that might be a case like AARP, or even a case like this one, where district courts could consider the availability of the class action device, but if it couldn't move fast enough, because Rule 23 doesn't include TROs and PIs, if it couldn't move fast enough in those contexts, courts might need to step in anyway. But I think we fit in the first bucket in this particular case, because the alternative ways of remedying our particular significant pocketbook harms to the tunes of millions of dollars can't be remedied, as the district court found below, without granting us this kind of relief.
Well, I mean, you could benefit through percolation and a decision from this court with reasonable expedition.
So I have no objections to reasonable expedition. We would have no objection to this court even setting supplemental briefing on the merits and hearing the merits directly. I'm happy to talk about the ways in which I think the merits do bear on this emergency application. But more fundamentally to your question, Mr. Chief Justice, I would just note that I don't think the alternatives actually fully remedy our injuries in a couple of different respects. So I heard my friend on the other side to specifically say today that maybe there can be an instruction to the federal government that at least when you're dealing with the plaintiff states, you treat these individuals kind of as though they're citizens, even if they're not really citizens. And that doesn't work, not just for the federal government. I agree, Justice Gorsuch, it may well be that the federal government can decide when to take its own medicine, but I'm talking about administrability burdens on the states, and I'm talking about administrability burdens on third parties as well.
Can I ask you a question about that, counsel? Your three buckets are very thoughtful. The first one seems to me kind of consistent with traditional equity, which is if it's required, if you've got to remedy the plaintiff's harm. That's your point there, and you're saying we fall in that bucket. I get that argument. The second bucket is possibly Article III, okay, that Congress could authorize, and maybe has authorized circumstances. But that doesn't answer the equity point. So we come to bucket 3. And I'm struggling to understand what the rule is there. You seem to suggest, well, if it's really important and if you have to act expeditiously, then go ahead. But I think every district court who enters one of these thinks that's what they're doing. So what's the constraint there? If you share the government's concerns about the rise of these things in the last few decades, what teeth does any of that have?
So I do feel like something of an amicus to this question because nothing in my injunction rises or falls on this third bucket. So I'm happy to answer questions.
I need all the amici I can get.
Fair enough, Your Honor. So I would say 2 things about that. The first is it does require reading the history in a way more like I do, which does not create a single bright line rule that this is never available. Obviously, if someone reads the history as saying
I'm spotting you that for the purposes of my question.
Great.
I'm not granting
I thought you might not, Justice Gorsuch.
But I'm spotting it to you, and I'm just saying, well, okay, what would that look like, and how would that be any different from what we have experienced over the last few decades?
So this is a way in which my first bucket and my third bucket are actually going to relate for a moment, so I think this is...
No,
it's helpful, I promise.
Don't get to squiggle out into the first bucket, okay? We're in the third bucket.
I'll answer for the third bucket, which is I think it requires having district courts consider the availability of the alternative and explaining why it's not workable in the case.
I think we've told them to do that, and... how many times do we have to tell them to do that? And I think, in fairness to them, that's they think they have. So let's, again, would any case over the last 30 years come out differently under your view of the rule in the third bucket than has?
Yeah, so there's a couple of examples where we don't think universal relief was appropriate. I'm most familiar with the state litigation, so most of my examples will probably come from there. But I heard my friend on the other side mention the DACA litigation, where Texas sought the termination of DACA, and ultimately the Fifth Circuit terminated DACA specific to Texas alone. And we thought that decision was exactly right because of the nature of the harms in that case meant that Texas could get full relief for its harms.
Well, now we're back to the first bucket. We're just satisfying
I take the point. I'm so
sorry. You see what I'm saying?
I take the point, yes.
I think I get that we're going to always revert back to the first bucket, but that means the third bucket's empty.
I totally take the point. I think AARP is a good illustration of the third bucket that this court confronted recently, where it was the case that there was this rush, just a few hours, not possible to go through class certification. You heard my friend on the other side talk about the rigors of class certification, and I don't think my friend on the other side would agree. It could be done in 3 hours through the night.
You can file
so there was
habeas,
necessity to step in.
Do you agree about the rigors of class certification? It seems to me that 23B2 classes, and you probably, if you have to, are going to be arguing
that they're
not so rigorous to meet for injunctive relief for national policies that are uniform.
So the most important thing that hasn't come up in the discussion this morning yet is that they're not available for state litigation. It talks about persons, it talks about appointment of class counsel, it talks about going through this certification process. States, this court's precedents are really clear about parents patriae lawsuits. States can't represent those individuals in class actions, nor would we try to. They can't represent us, and you don't have classes of states. So the whole framework doesn't apply to state litigation. So I understood how it might come up as an alternative for some other cases you might see in the future, but for the injunction you have in front of you from the states, the whole class device doesn't even work as an alternative. So I don't see how it can be the answer for us.
But why should you care if the class device doesn't work as an alternative if you have bucket 1? Like you don't really need the class device. I think what you're saying is, well, it'd be frustrating for states not to have the class device when the individuals have it, but I don't see why that's true if giving you complete relief in bucket 1 solves your problems.
So I should be very clear, and I'm sorry for the confusion on this. This goes back to my colleagues with Justice Gorsuch. When states are seeking the relief, states are seeking it in bucket 1 and bucket 2. As an amicus to the other injunction I recognize courts are looking at, I think bucket 3 could be available. We aren't seeking relief when it falls into bucket 3 because, as I was saying earlier, we're not going to be seeking relief for other parties. This court's cases, like Brackeen, make very clear we aren't suing to vindicate the injuries that third parties and our residents are suffering. So when states come before you, the questions that you would ask are the alternative ways of remedying our injury going to be practically or legally workable? And you're going to ask, Did Congress authorize it, which gets to the vacator question, which gets to the Hobbs Act question, and so on. And on that first bucket, which I think describes this case well, I had a hard time with some of the colloquies earlier today because I think they were missing some really serious burdens that the states are still going to have to bear in this case if we get something less than a nationwide injunction. I think it's going to hinder the administration of our benefits programs. I think it's going to hinder the participation in our benefits programs. And I think it's going to produce unprecedented chaos on the ground. And I might offer examples of each.
Before you do, I'm sorry.
The illegal alien.
How would you get this? How would you get the merits of this case to us promptly?
So there's two different ways that this court could think about doing it. So the first is, I heard a couple colloquies earlier today to suggest that maybe the states should sort of have to take some of the burdens on ourselves because, okay, some people move in, maybe that's just something that equity shouldn't care about. And it may be true, this is Hornbook equity, that in some cases states don't get complete relief for the harms that they suffered. We just have to eat some of the administrability burdens. But the merits have always come into that, because that is just about remedying a party's own injuries. And the strength of the ability to remedy our injuries is going to turn on a peak on the merits. This is partially Ohio versus EPA and building on Justice Kavanaugh's Labrador concurrence, where this court said you might have some states who really like a policy and some states who want to get relief from the policy, and how you reconcile those two things, who should get relief, who should benefit from the policy, will turn in part on a peak at the merits because we have a greater right to relief from it.
I appreciate that. How do we get to the merits fast?
This court could set supplemental briefing on the merits by an order tomorrow if it wished, specifically to say the federal government has proposed that states get less than complete relief in this case. We could not possibly think about giving the states less than complete relief without looking at the merits. We want briefing.
Put that aside. Assume we've just got the remedial question before us, and we're going to decide the remedial question one way or the other. Then what?
Oh, then I share some of Justice Kagan's concerns from earlier that it would rely on the United States.
I appreciate you share those concerns. How would you address them? How would the states plan to get this case to the court promptly?
I think it's very hard to think about how the states would lose this case given the state of Supreme Court precedent. It creates very weird incentives on the certiorari docket when there's already binding precedent from this court. We do suffer harms from the application of this executive order beyond our borders that we need relief from. If we don't get a full remedy from that, I suppose we could ultimately seek cert before judgment on the basis that we still have Article 3 injuries that we're suffering, but we'd be asking this court to grant review from a circuit precedent we won on the basis that we have continued injuries. It's not impossible. This court knows best when it grants cert and when it doesn't. I would think it's not the cleanest way to tee up a case historically, and so it would raise some real concerns to the colloquies earlier today about how this case would ultimately come before this court.
Are you telling us that we really can't decide the question that we asked to have briefing and argument on without taking a peek at the merits?
So I'm not saying that at all. So there's two different ways to think about this case, Your Honor. One is to say, absolutely, the states need to get complete relief for their injuries, and then let's figure out the best way to do it, and we think the alternatives are not workable and not legal. If this court is going to entertain giving us anything less than full redress for all of the Article 3 injuries we bring before you, I don't see how that can be entertained without a peek at the merits, because you always look at the merits to decide should we get 100% or 90% of our own injuries redressed.
Well, would a decision on the matter that I understood to be before us, the narrow question that I understood to be before us, be helpful in any way if we do not peek at the merits and we also do not decide whether you have standing?
So I'm not sure how you could decide whether or not we got an appropriate scope of relief without figuring out what our own injuries are. Because how you decide, this is the United States' own argument, how you decide whether or not we should get relief for our own injuries turns on what our injuries are that require relief. And so I do think we have pretty significant pocketbook injuries like in Nebraska to the tunes of millions of dollars. And whether we get those remedies or don't get those remedied is going to turn on the merits, is going to turn on the nature of the harms, and then ultimately the workability of the alternatives.
Thank you, counsel. Justice Thomas? Justice Alito?
Well, General Sauer began by outlining problems that he sees being created by universal injunctions. And he said that the issue was a non-ideological issue and a nonpartisan issue. Do you agree with that?
I do think presidents of both parties have objected to nationwide injunctions. I agree.
So what do you say about the the practical problem. So let's put out of our minds the merits of this and just look at the abstract question of universal injunctions. What is your response to what some people think is the practical problem? And the practical problem is that there are 680 district court judges, and they are dedicated and they are scholarly, and I'm not impugning their motives in any way, but sometimes they're wrong.
Boasberg, Zenas.
And all Article III judges are vulnerable to an occupational disease, which is the disease of thinking that I am right and I can do whatever I want. Now, on a multi-member appellate court, that is restrained by one's colleagues, but the trial judge sitting in the trial judge's courtroom is the monarch of that realm, and there are situations in which trial judges, the president does something. It could be President Trump, it could be President Biden, it could be President Obama. The trial judge says this is unlawful, and I'm going to enjoin it. And I'm convinced I'm right, so I'm not going to stay the injunction. And then
all over the place.
An application is made to the Court of Appeals to stay the injunction. The Court of Appeals gives it the back of the hand, and then the case comes immediately to us in the context of an emergency application. And some of us have said, well, we don't think we should do anything in those situations unless it is indisputably clear that the court below was wrong. So what do you say to that practical problem?
So we're mindful of the practical problems. I will say the states have had a through line as well across administrations. We have never believed, even as nationwide injunctions restrained policies that we favored, that they were categorically off the table. We've always taken the position that they are sometimes available in narrow circumstances, whether we like the policy or don't like the policy. And so you might have some cases where the nature of the harm, this is the DACA example from my friend on the other side, where the nature of the harm which was Texas saying it had to give benefits to residents in the state, is actually entirely remedied by a nationwide, state-only injunction that applies just to Texas, because that might incentivize individuals to leave Texas, and then Texas doesn't have to give them benefits anymore. So you might have a case like that. But sometimes you are going to have cases where it is impossible to remedy the state's own injuries, and the alternatives are not practically or legally workable. And that describes this case perfectly. And so I don't think the answer is a bright line that means even in those situations, it's not possible for the states to get relief.
In deciding the question that is before us here, do you think we should, never mind, I withdraw that. I have no further questions.
Alito's done.
Justice Sotomayor?
Here we go.
Let's start with an answer you've been trying to give and haven't completed, which are the general suggested there were two ways that your injuries could be remedied. He claimed they were both presented to the court below. I didn't see that, but that's a matter that we could check on. Do you agree with me that they were not presented to the courts below?
I do agree with you. So I want to be very clear, because I think there's some confusion across the briefing here.
Right.
We agree, and I don't think the First Circuit disagreed. They objected to the nationwide injunction in the district court, and we attached the briefing and we attached the transcript. What they didn't do is provide some of the alternatives they've pressed in two sentences in their emergency application.
Okay.
Yes, they did not.
So now go through why you question whether there are two suggestions now that they've only raised before us are inadequate to remedy all of your harms.
Yeah, so
because complete relief, he says that there is situations in which you grant relief that will benefit third parties. Why is your relief necessary to give you complete relief, even though it benefits these parents in other jurisdictions?
So I don't think there's any serious dispute that if you limit the relief to babies born in New Jersey, we won't get complete relief, because 42 U.S.C. 1396A, the Medicaid statute, requires us, the states, to do the citizenship verification. So it's not true that they can simply handle it all for themselves. Federal law requires us to undertake those responsibilities. And we have, in New Jersey, 6,000 babies born out of state every year. When they come into the state and they need benefits, the Boyle Declaration from Massachusetts suggests that's going to cover 40% of kids. They come into our state, they need benefits. We have to do citizenship verifications, which is a burden for us.
That's for you in New Jersey, but there's, I think, how many states?
That's just an example. We have 23 attorneys general in this case.
23
exactly right.
attorney generals. So 23 states are going to have babies who were born somewhere else without a birth certificate that you're now, if they move into your state, going to have to do checking on.
And that comes to the United States' alternative, Justice Sotomayor, which is they say, okay, maybe their citizenship turns on when they enter New Jersey, maybe for some purposes, maybe for all purposes, depending on which sentence you're looking at in the emergency application. And there are three problems either way. The first is it will undermine the administration of our benefits program. So individuals will move in. When they were born, they were treated as non-citizens. They didn't get Social Security numbers because they wouldn't have been eligible for the enumeration at birth program in their states. And they're going to arrive and they're going to seek benefits that we administer. But federal law requires that they have Social Security numbers for the administration of those benefits. This is 7 U.S.C. 2025 for SNAP. This is 42 U.S.C. 1320b7 for TANF, for Medicaid, and so on. So they're going to need to have Social Security numbers. They're going to arrive without them, even though they were, under this court's precedents, citizens who should have been in the enumeration at birth program, who should have had Social Security numbers. And it's going to be a burden on us, either in delaying the benefits, training county social service workers, and having to administer benefits without the SSNs on a provisional basis. So that's the administration of the benefits. Let me give an example on participation, which we have responsibility for as well.
Yeah, Sotomayor's not interrupting this dude at all, is he?
That their families were told that the babies are undocumented, they aren't citizens, they're not eligible for these federal programs when they were born. They come into our states, they think they're now ineligible. They don't realize their child is a citizen entitled to these federal benefits. And so what will happen is we bear the responsibility, putting in our own state Medicaid plans, of getting them enrolled. And that's 42 U.S.C. 1367BB. So we're responsible for putting in our plan how we're going to enroll them. We have to incur substantially more costs to get them enrolled in our programs because they think they're undocumented, they think they're ineligible because of where they were born, even though their citizenship has now turned on when they cross state lines. And then the last point is, we've never in this country's history since the Civil War had your citizenship turn on when you cross state lines, so we don't have answers to these workability questions, not just because it wasn't presented in the district court, not just because it's 2 sentences in an emergency application, but because for over a century, executive practice has been uniformly to the contrary, building on this court's decision in Wong Kim Ark. So we genuinely don't know how this could possibly work on the ground. And although my friend on the other side has complained that they weren't able to give guidance, the states didn't object to guidance. The states have no quarrel with internal steps. And if they want to put out guidance that says, if Wong Kim Ark gets overruled, this is what we would do, that's fine. What they can't do is require us to take any steps or issue guidance that requires everyone to start planning for something that is so patently against this court's own settled precedent.
Now, going back to the history question that Justice Thomas started with, you relied on the Bill of Peace, you relied on the tax injunction of the 19th century, and not so far in the 19th century, 1891, just about the time that the 14th Amendment was adopted, okay? At any rate, there are other cases, one of our amici points out to them, the Pierce versus Society of Sisters case, the West Virginia State Board of Education case, those were earlier than the 1960s. In the Pierce versus Society of Sisters, the court affirmed a universal injunction that wasn't even sought by the parents, correct?
That's right.
And there what we said was their states were imposing criminal penalties on parents who sent their children to private school. And just 2 plaintiff schools sued against that penalty. They sought and won an injunction that categorically restrained the state from enforcing the law. That was 1925, correct?
That's right.
And similarly with West Virginia, saluting the flag by Jehovah's Witnesses.
She's doing his argument for him now.
The injunction was universal. So in answer to Justice Gorsuch's point—
I'll answer it for you.
We've had universal injunctions in some form.
Is he laughing?
Correct? Since the founding.
That's right. If I can make 2 points on that, Justice Sotomayor.
Correct?
Exactly. So I agree with your reading of the equitable history, that it goes back from the English Pill of Peace—
Thanks, Judge.
—through Equity Rule 48, through the tax collection injunctions, through Equity Rule X, through the Ex parte Young period you're referring to, through AARP just a few weeks ago. So I agree with your read of the history. But I just want to make one quick point.
Well, let me Go ahead, make your point, but I want to finish this thought, which is you started earlier by saying universal injunction should not be the preferred remedy, and it should be limited. You've suggested 3 ways to limit it. I agree with you, those 3, and yours clearly falls within one. That's your claim. But the point that I think my 2 other colleagues are raising is, how do we ensure district courts are following that?
So if I can make a point about the history and then make a point about the guidance. On the history, I understand that the United States at the podium today tries to make the history all about what it calls indivisibility cases where there's just a unitary on-off switch, as it were, and either something happened or it didn't happen, like a redistricting plan needs to be completely redone or a power plan is on or it's off. But if I could give an example that shows it's not quite so limited and it very much requires looking more broadly at what's practically or legally workable on the ground, I would point to apportionment as an example. So say that there's an executive order that says we're just not going to count minors, people under 18, in apportionment anymore. We're only going to count people who are voting age. And the state of New York files a lawsuit, and it wins its lawsuit, and all of its 17 and under-year-olds get counted for apportionment. That isn't indivisible in any way. It's not a redistricting plan, it's not a power plant, but it is going to skew apportionment in a way that is totally unfair, practically and legally, to third parties, because now 17-year-olds are being counted in New York, but they're not being counted in Oklahoma. And you would end up messing up apportionment between states for that very reason. And that shows, as just a broader insight, that we've always looked to the harms that third parties will suffer as negative externalities of court orders. And that's our submission here, that to accept what the United States wants as against our injunction and to say that it turns on or off when you cross state lines doesn't just harm the administration of our benefits, doesn't just even harm enrollment in our benefits, also puts chaos on the ground where people's citizenship turns on and off when you cross state lines. If ICE has initiated a removal proceeding when you live in Philly and you move to Camden, I suppose the ICE removal is supposed to turn off at that point, potentially, because your citizenship status has changed. I don't know if you lose it if you move back to Philly, whether you were born in New Jersey or born in Philly, move to Camden and move back. It's a very porous part of the country. I don't know if the ICE removal turns back on when you cross state lines again. And that sort of chaos on the ground, those implementation questions we don't know, are serious third-party harms we've always taken into account. This is North Carolina versus Covington, where courts ask what's workable as an injunction matter. And it's also the winter factors, where factor 3 looks at the balance of the equities between the parties and workability and harm to them, and winter factor 4 looks at public interest and the negative externalities and workability problems we're imposing on others.
Justice Kagan?
General, you've had a chance to talk about your administrative costs and the workability problems that New Jersey would confront, but how about this magnet problem? I mean, it strikes me as completely obvious that if you have 2 states and they have different rules for citizenship and one benefits babies and the other doesn't, that everybody moves to the state where the more favorable rule exists. But why is it that preventing that harm from happening should count as providing you with complete relief?
So I think actually my point is somewhat different. I agree with you that the incentives could potentially factor into the calculus because we're ultimately experiencing some harm we might not otherwise to our benefits programs. But my point is different. Even if you just take normal migration for New Jersey, 6,000 babies born out of state, 8% or 8 million every year traveling across state lines, without worrying about the incentives, we're going to be looking at that problem for how we administer benefits programs.
I got that. Are you saying we shouldn't consider?
No, I think you can. I think you can, Your Honor, and it's because of the nature of 3 things together. One is it's the movement, but it's not just the movement. 2 is it's the fact that citizenship historically was something you had at birth or didn't have at birth, and so you arrived to our state, in theory, without birthright citizenship because you would have been told when you're born in the hospital what you have or don't. And then the third, and this is really important, is the way that citizenship permeates so much, not just for individuals, but for what states are obligated to do, whether it's citizenship verification eligibility, whether it's enrollment in our own programs. Over and over, you see citizenship in Congress's own laws as the on or off switch for our own administration of benefits, and that's actually sort of unique. So I don't think every time people move between states, you automatically need to have a nationwide injunction. What you need is a demonstration about how that's going to contribute to the state's harm, and then, I think this is really important to colloquies you were having with the United States earlier, a court could, in an appropriate case, say, well, sure, state, you might have to keep some of the harm. We're only going to remedy 90% of your harm because it's too disruptive to everyone else. But I don't think you can do that in a case without looking at the merits, because whether we should get to 100% of our injuries taken care of or 90% of our injuries taken care of will always involve the strength of our merit showing, and I don't see how you could have a stronger merit showing than we have here. 127 years of Supreme Court precedent, over a century of executive practice, and congressional statutes that codified both into law in 1940 and 1952. And given that strength of the merits and the settled precedent, combined with our nature of harm, I don't think this is a close case for why we need national relief to remedy our injuries.
Thank you.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
I have a question about the history. So Grupo tells us that we have to look back to 1789 in the High Court of Chancery. So I appreciate that there have been some cases from later, and you were talking about some of those with Justice Sotomayor from the early 20th century, maybe the late 19th century. Can you say, and let's say that I think the Bill of Peace is more like a representational suit that is the forerunner to the class action. What do you think is your very best example of something that would look at the period that Grupo tells us is relevant, that would support something that looks like universal relief?
So I do think from 1789, from English equity, I do think the best example is the Bill of Peace, and so I understand if we see it differently, it's a fair point. I will just say quickly on Grupo Mexicano, its own tradition, and this is sort of the analogical reasoning you talked about in Rahimi, it looks at that period, but in other times we've also looked at American tradition to see analogically how we've liquidated that tradition or not. And in American equitable tradition, this is Equity Rule 48, which specifically said non-parties are not bound by certain relief, and even as they may benefit from it. And I take that to be the principal reason my friend on the other side thinks that bills of peace look much more like class actions than they ultimately look like universal injunctions. And Equity Rule 48 was to the contrary. Tax collection injunctions in American history were to the contrary. So I just have a hard time with that reading, even though I agree with you that you would be starting in the founding trying to do analogical reasoning based on what Grupo Mexicano says, but using American equity to answer some of the unresolved ambiguities.
I completely agree with you. Need some analogical reasoning, and I don't think that Grupo completely rules that out. And I think even if you talked about the distinction between a Bill of Peace and a class action, you would be looking at some of that doesn't have to be called the same thing. I think the problem is when we have such a party-centric history, if it has to be reasoning that fits within the confines, then I think we have a little bit of trouble. Let me just ask you one question about relief. So let's say that I think that the states do need something broader in order to have complete relief, even if the universal injunction is too broad and inconsistent with Grupo. That isn't how the court below approached the question, because that isn't what the court below thought it had to do, because the court below thought it could just enter a universal injunction. So how would I go about crafting some sort of holding or decretal language that would take care of you and the fact that you need maybe broader complete relief than maybe an individual plaintiff would, right? Because the district court didn't go through that analysis, the analysis that you're telling us today. So tell me practically what that would look like.
So I think the district court in the Massachusetts case did actually do a very good job of this. It specifically said, I'm saying New Jersey as a stand-in, 23 Attorney General. Yeah. The states need this relief. And he didn't grant universal relief to the individual plaintiffs in that case. So he did actually craft different relief for different parties. And he said, this is necessary for us. Part of why we're talking about alternatives in a different way at the podium today is because these alternatives were not presented to the district court. So the district court just had before him the idea that maybe we have to eat some harms or maybe we get universal relief. And of course we need universal relief given the strength of the merit showing as between those choices. I think what you could say is here there were two sentences in an emergency application that raise new alternative ways to remedy the harms. Those sorts of things need to be raised to the district court, and when they are raised to district courts in appropriate cases, when states file suit, courts should ask first, are those alternatives going to be practically or legally workable for the plaintiffs and for third parties? I agree to Justice Gorsuch's point. If the federal government wants to take on its own burdens, it can do so, but it can't just say that for third parties.
But you're talking about what would happen in the future. I'm talking about what would happen to you now.
Oh, so I think if the United States seriously wanted to press these alternative with facts about how they would work and put that before the district court, parties can always put new alternatives in a motion to dissolve an injunction before the district court. That's something that has happened regularly when there's changed circumstances or new alternatives. They're welcome to do that in this case or in any other, but then they're going to have to put forward actual facts about how it's practically or legally workable. I will say on its face, these two sentences don't look practically or legally workable for the reasons I raised, but they'd have to make that showing in the district court in the first instance.
Thank you.
Justice Jackson?
So I guess I'm kind of hung up on the posture in which we find ourselves looking at these issues. Justice Alito, I think, focused on this a little bit, when he says that the district court makes this initial determination. It turns out to be wrong. The remedy, I thought, was to appeal. And I guess, for me, the question is whether and under what circumstances the government keeps on doing the thing that the court has found unlawful while the litigation is proceeding to determine whether or not the government's activity violates the law. We're sort of in an interim posture. Many of your arguments, and I appreciate them, are kind of couched in, the state is going to need complete relief for their injury, and that's true definitely as a final matter. But here we are at the beginning of this litigation. No one has determined whether or not the government's conduct is actually unlawful. We have a district court, several district courts, and now courts of appeals that say it is. And so, as an interim matter, we are saying the government has to stop doing it while we litigate the issue of the unlawfulness. To me, that kind of puts the whole thing in a different frame. It's sort of like, why isn't the question in this posture, in this circumstance, can the government or has the government shown that it is going to suffer some sort of harm from being made to completely stop this activity while we're litigating the lawfulness of the conduct? I don't understand. And then you say, yes, we're going to suffer harm. This is the balance of the equities that, part of the PI and the stay showing. But I just don't understand why that's not the focus here. And I don't know what I apologize because I didn't get a chance to ask Mr. Sauer this, and maybe he can address this on his rebuttal. But, what problem is the government facing as a harm matter from being completely told it has to stop doing this while we, the court system, determine whether or not its conduct is lawful?
So we included this in our application. We do think this case is quite unique in that I do think it's hard for the government to show in this particular case that it needs to be able to act contrary to this court's settled precedent. That's obviously come up in a couple of questions today. It's something, if I realize the elephant in the room, I've often been asked to assume that the merits are put to the side, and I'm fine assuming that for those questions. But to your point, you're not wrong. It is quite striking, obviously, that it's not just that district courts are saying, this looks like it might be unlawful. They're saying Wong Kim Ark settled this exact issue 127 years ago. This court has reaffirmed it since. Over a century of executive practice is built on that, and Congress has codified that directly into law. So I do think it's a particularly unusual case for the government to be saying that it has been quite so harmed and needs this kind of relief. But at the end of the day, I'm happy to join issue on when relief may or may not be appropriate, and I just think we're clearly on the positive side.
But you're saying that at least in some circumstances, from your perspective, in order to even decide whether or not you are entitled to an interim complete injunction, the court's now going to have to peek at the merits while the merits are being litigated.
I think the court always has to peek at the merits in deciding whether the party itself should be getting relief from its harms, including complete relief as even the United States accepts. So those are all four of the winter factors. You have to figure out what the irreparable harm is that you're trying to deal with. You have to figure out if we have a sufficient merits showing in order to eliminate that irreparable harm. And depending on the strength of the merits showing, you're also looking at winter's factors 3 and 4. So this court has given 4 winter factors that I think are quite useful in most cases. I took my friends on the other side to be saying, well, beyond the winter factors, there's this bright line rule from Article 3 or the history of equity that just says it can never get to this point. I obviously disagree a bit with them on the reading of that history, but I just think it has no bearing on the case that the states bring to this court here.
Thank you.
Thank you, counsel.
All right. Wow. That's going to be it, my friends. Let's see if there's any other commentary before they close it out.
Ms. Corcoran?
Oh, we got another Attorney General?
Mr. Chief Justice, and may it please the court, The executive order's stripping of citizenship from U.S.-born children is contrary not only to the 14th Amendment's plain text,
no, it's not,
but also our common law history, this court's precedent, a federal statute, and over a century of executive branch practice. Every court to have considered the issue agrees that the order is blatantly unlawful, a determination the stay application does not challenge. The government instead argues that Article 3 and equitable tradition categorically prohibit providing non-party relief from the order's enforcement, regardless of the order's illegality or the irreparable harm it inflicts. The government is wrong. It is well settled that preliminary injunctions may benefit non-parties when necessary to provide complete relief to the plaintiffs or when warranted by extraordinary circumstances, both of which are true here. The court should reject the government's efforts to stay a preliminary injunction that maintains a status quo all three branches of government have ratified and operated under for over a century, and that prevent the catastrophic consequences that will result for the plaintiffs and our country if the government is allowed to execute an unconstitutional citizenship stripping scheme simply because legal challenges take time. I welcome the court's questions.
You say the government is wrong about the availability of preliminary injunctions. On what do you base that?
So I think the two reasons I identified, one, it is well settled, and I understood General Sauer to agree today that universal injunctive relief is appropriate when necessary to provide complete relief to the plaintiffs. That is the case here, and I'm happy to talk about that. But I also, this court has long recognized the availability of universal injunctive relief in extraordinary circumstances where it's justified. I think I would focus particularly on the public interest and equities prongs of the Winter test, and I'm happy to talk about that as well, but I think those are the two reasons the government.
Do you think that if, even if one considers the history not to support you, that the pragmatic considerations and the policy considerations should override that?
So again, I would put us in the complete relief bucket, so Mr. Feigenbaum, I'll put on my amici hat in answering that question. I understand General Sauer's proposal to be that we channel all of this through Rule 23. I think that is a historical one. It's inconsistent with the Rules Committee's understanding of the rules. Both, if you look at Rule 23, Rule 65, and Rule 71 together, they establish that Rule 23 is not the channeling mechanism that the government's suggesting. I'll start with Rule 71 because it's responsive, Justice DeBarrett, to your question earlier about whether non-parties can enforce orders. Rule 71 explicitly contemplates that and says if a non-party receives relief, they are entitled to enforce it. I'd point also to Rule 65, the preliminary injunction rule. In 2017, the Rules Committee considered a proposal from Professor Bray to amend the rule to prohibit relief to non-parties. The committee rejected that proposal because it found that it ran afoul of the Rules Enabling Committee. And then I'd end by pointing to Rule 23 itself, which says nothing about it being a channeling mechanism. In Principe v. Scarborough, this court said, we don't treat the rules as excluding background equitable practices. And here, Rule 23 doesn't even contemplate preliminary relief. It's focused on permanent injunctive relief, and I think that's because, as we've been discussing, it's very difficult to get class certification in time to have preliminary relief, so you're doing putative class relief, which is the exact same thing as what's happening here.
Well, why can't you get putative class relief in a preliminary injunction or TRO posture?
You mean, in the
get relief for a putative class in a TRO or PI posture?
I certainly think you can. The court did that recently in AARP.
They did do that.
My point is when the court does that, it's relying on the equitable authority it has to enter that sort of relief, not on the Rule 23 mechanism, because the class isn't binding until after certification, until after final judgment.
If that mechanism is available, whether one way or another, doesn't that solve a large part of the problem in a way that complies with the rules, the problems with universal injunctions that have been identified by administrations of both parties? Go through Rule 23 and do what's needed there, and people are bound then, so that's a wrinkle. But why doesn't that just solve the problem?
Right, so they're not going to be bound until after you get past class certification. So we're talking.
I understand that.
And for that reason, I would go to Justice Alito's point earlier that all you're doing is taking the non-party injunctions that are happening now outside of Rule 23 and shoving them into Rule 23. It doesn't address the forum selection concerns. It doesn't address the concerns about the emergency docket.
It complies with the rules. I mean, that the law, we care about technicalities, and this may all be a technicality. But it seems to me the technicality of Rule 23 and the history of that provides, 23B2 provides a mechanism to do what's needed here in terms of getting relief to people.
Nice to hear
and
that.
if you have PIs available for putative classes, that seems to solve the issue for preliminary relief and the timing issue as well.
So B2 provides for permanent injunctive relief. It does not provide for preliminary injunctive relief. Again, Rule 23 does not purport to be the exclusive channeling mechanism. And as I said, the Rules Committee doesn't think it did. So it would be this court kind of projecting its own policy decision to treat Rule 23 that way. And I would come back again to Justice Alito's concerns. That is not actually addressing the court's emergency docket. It's just now we're slapping a label of class certification on it. So I would, and I'll make a second point on that and then say what I think the better way of approaching the problem is, which is I think that General Sauer and I are in agreement that the Venn diagram of cases that are appropriate for class certification and where injunctive relief I think would be appropriate is not coterminous. I think we could pursue successfully class certification here. I heard General Sauer to disagree, and I think it's because they're just different circumstances. If you look at the class certification requirements, commonality, typicality, they were actually added to Rule 23 in 1966, mostly to address the expansion of class certification to include damages suits. That makes sense there. But those were never requirements prior to 1966.
Ms. Corcoran, on the class certification point you've been developing, one response might be, and I just want to get your reaction to it, that by proceeding through the class mechanism, even a putative class mechanism, a court is making a preliminary assessment about who are the parties going to be before it and issuing interim relief so that it preserves its jurisdiction to issue final relief with respect to those parties. And that's very different, the argument would go, than simply saying everybody everywhere, nationwide, universally, or perhaps cosmically, stands to benefit from this decision without ever having to suffer being bound by
illegals all across the galaxy.
So I would say, again, that's an ahistorical approach. You haven't had that sort of Rule 23
assume for the moment that we read bills of peace, which I understand to be your best set of cases, to be prototypical of what is now Rule 23.
Right, and so the bills of peace and kind of going through, as Mr. Feigenbaum was talking about, Equity Rule 48 and then 38, in none of those circumstances were we doing this ex ante class certification determination. So the modern class action device actually looks quite different than it was for representative suits historically. So it would be putting on an ahistorical constraint.
I appreciate that argument. Okay, but now we're haggling over the history, which we have to do. I accept. But if bills of peace are understood, again, accept the premise, to be predecessors of Rule 23, then respond to the point that there is something fundamentally different about a preliminary injunction to a putative class that you found is likely to be certified and likely to succeed on the merits in order to preserve that court's jurisdiction to award ultimate relief to those parties before it, and that's categorically different than a universal injunction.
So starting with the presumption that was different about the bills of peace is that they were binding, I think sometimes, it's not clear always, at the end when they were getting to final judgment. I would go back to Grupo Mexicano, to Justice Barrett's point, although that was the high watermark of this equitable originalism, the way the court articulated the test, it focused on 1789, but the actual analysis in Grupo Mexicano focused on 1890 through 1942. And what the court found there is that there were numerous cases expressly rejecting the Morava injunction, and that was confirmed in the 1970s when England adopted it and said, no, we've never done this before. We are in an entirely different world here. One, the cases that Justice Sotomayor laid out earlier all come from between 1890 and 1942, and they suggest that non-party relief was provided for outside of the class action context. But the fact that we have, I think, these very studied scholars in this rigorous debate about what the bills of peace meant, what the railroad cases meant, I think shows that this is very different in Grupo Mexicano. And for the court to kind of delve into that and adopt the categorical rule that the government is suggesting, I think is certainly an overcorrection. It's a hornet's nest on Article 3, right? It calls into concern APA, class action, a whole sort of things. I would suggest that the court instead focus on providing limiting principles within the confines of the Nikin factors of the winter.
Is there a practical problem? So I want to put aside the history, and I take your points on that, and why you don't think Rule 23 fits. I take your point on that. But if putative class actions and preliminary relief are an option, what then is the practical problem you see as distinct from the current regime?
Well, if General Sauer is right in that there are class certification problems here, then in this particular case, you're going to have thousands of
Okay, I think suits. You would be arguing that the class should be certified here.
Right, but I'm saying the government is
so more generally, taking it out of this case, if you could, do you see practical problems?
They want another option.
It would eliminate the associational standing trade cases, the cases brought by the Chamber of Commerce, the NRA, other associations that aren't suitable for class certification. I think also the questions again.
Can you explain that?
Well, they wouldn't. So if we were to seek cert, it would be on behalf of our individual plaintiffs. For the same reason that the government would have difficulty seeking class certification. The state government, I think, associations are not necessarily a good fit for that framework. Again, that's also not solving the court's problem. It's just channeling the problems through a different mechanism.
I don't think that can be solved, just to be honest, but that's a separate issue from what the right rule is as to how things transpire in the district courts.
Could I perhaps try to solve it in a different way? What I would suggest, we spent some time trying to catalog the cases in which this court has approved universal injunctive relief and the cases in which it's rejected it with the aim of giving the court maybe a suggestion on how it might affirmatively articulate some limiting principles such that you would not be getting the injunctions that the court thinks are inappropriate, but the ones that the court has approved would still be able to proceed. Again, that's not the categorical rule that the government is suggesting. I think roughly what the court has been doing is saying that universal injunctions are appropriate only in facial challenges involving fundamental constitutional rights where there are real concerns about whether just the legal and practical availability
so she wants a new test.
Relief to similarly situated parties who are also going to experience irreparable harm. I think that maybe explains
that
AARP.
Will protect against
most
these
recently,
overuse of
IRAP
injunctions.
would fall into that category. Chrysophus, the New York eviction case, would fall in that category. On the other side of the ledger, the court seems to disapprove quite a bit of nationwide injunctions involving discretionary benefits. So that's some of the recent ones that you have undone or stayed. So I think what the court could do is kind of identifying limiting principles that would provide guidance to the lower courts on when it's appropriate to issue these injunctions. The natural home for that is the public interest prong of the winter test, right? If you're going to issue an injunction that's going to have an impact on other people's, you need to be doing a really muscular public interest assessment before doing that.
So she wants a new test.
That's what I would urge the court.
Ms. Corcoran, are you pushing back on the class certification idea because you're worried that there are cases where there will be no certification?
You'll lose. That's why.
In which,
she's worried she'll lose.
Broad relief is in fact appropriate, so that the two categories don't line up. And if that's why you're pushing back, why are you worried about that? What are the cases you're worried won't line up properly?
Because they're not a class.
The government has suggested it's going to argue that here. Again, I think the commonality, so thinking about questions like common injury make a lot of sense when you're talking about class-wide damages, less so when you're talking about a facial challenge to a constitutional violation. So I think it's a bit of a mismatch. And again, it's not what Rule 23 was ever intended to do. And it doesn't solve any of the court's policy problems. So I think it's a lose-lose-lose proposal that the government
they want multiple options.
I'm a little concerned that I have focused a lot on my amici hat and haven't actually explained to the court why the injunction is necessary for complete relief here. But I don't want to pivot too quickly, but I want to make sure I address our primary argument as well.
Tell us why it's necessary for complete relief.
Thank you. For two reasons. The first is that a plaintiff-specific injunction would not be administratively workable. I'll explain that in a second, but I want to note the second one is that even if it were workable, it would require the association members to identify and disclose to the government an association that puts them at great risk of adverse consequences, detention or deportation, even if they're here lawfully. And so it's not complete relief to require the plaintiffs to make dangerous disclosures in order to claim the constitutional right. And then maybe I'll pivot back to the workability unless there are questions about that. Yeah. Sorry.
Very briefly, and then we'll move on to the next stage of our questioning.
Roberts.
So the government's workability argument with respect to the individual plaintiffs, the private plaintiffs, is wholly tethered to its argument that the injunction should be limited to the 16 named plaintiffs. It has offered no argument for how it would administer, how state and local agencies could administer an injunction that was narrowed to the ASAP and CASA members. So I think that's probably the end of the road. Mr. Feigenbaum made the point that they can always go back to the district court and ask for the injunction to be dissolved if they present some sort of workable proposal. They haven't, and I don't think they can. I don't want to talk for too long, but if anyone is interested, I'm happy to answer questions about why I think it's
I'm sure someone will be.
Yeah.
Thank you, though, counsel. Justice Thomas? Justice Alito?
Should we decide or make up our minds on the underlying birthright citizenship question without briefing and argument and deliberation?
I think that we would be very eager to do supplemental briefing on that. General Sauer noted that none of the parties had asked for cert before judgment. We couldn't because we keep winning. I will ask right now for cert before judgment.
What's the answer to my question?
Yes, I think you can grant cert for judgment.
That wasn't my question.
Yeah, but I will say,
all right, all right. You don't want to answer it.
No, I will. I have if I could give an answer, which is that I think it's very difficult, if or not impossible, for the court to do a meaningful in-ken analysis without taking into account the fact that the government is asking the court to allow it to ignore this court's precedent, to ignore a duly enacted statute, and to upend 100 years of executive branch practice. So I think, although the government has attempted to separate them, that really the merits are embedded in the in-kind factors.
Justice Sotomayor?
No.
I find it hard to understand
how
a district court, in looking at a preliminary injunction under the winter factors, where we said that the likelihood of success on the merits is the keystone, how we could separate that out and say the keystone of whether you're entitled to universal injunction is the only merits question because the other factors are not eliminated by winter. You have to balance the equities, and you can't balance the equities without the merits, correct?
I think that's right. I think also, irreparable harm is going to be very difficult for the government to prove if it's not contesting or at least not defending the constitutionality of the order, because the government has no interest in enforcing an unconstitutional order. I'd also note there's a quote from Professor Bray in Justice Gorsuch's Texas Concurrence, and it's, "In equity, it all connects. The broader and deeper the relief the plaintiff seeks, the stronger the plaintiff's story has to be." So I think there really is kind of an equitable consideration here of the merits as well that just can't be extracted from the...
Now, the state has explained why it can't pursue class actions. So it admits it's limited to whether it's entitled to complete relief. But how about your organization? You sort of answered it, but I wanted to pin you down on that.
No,
Do you believe that associational organizations can seek class action?
I believe our individual plaintiffs certainly can.
Yes, there's no question.
Yeah, I am nervous about the government's suggestion that it's going to oppose our class certification motion if we were to file one. I mean, class certification can be very discovery intensive. It could be the sort of thing that really
That's
delays
why they don't want it,
our plaintiffs from getting the relief that they seek.
Thank you.
Justice Kagan?
Because what I worry about here, Ms. Corcoran, is that this case is very different from a lot of our nationwide injunction cases in which many of us have expressed frustration at the way district courts are doing their business. And, you know, the typical way in which that frustration emerges is that legal questions are hard and they're complicated, and different courts would decide them differently. And instead, because of the forum selection process, a party goes to one place. You know, in the first Trump administration, it was all done in San Francisco. And then in the next administration, it was all done in Texas. Right. And there is a big problem that is created by that mechanism. And that leads to the questions to you and to General Feigenbaum, which is like, you know, your third buckets, which are, if it's like super important, or if it's quintessentially national, or whatever the way,
whatever little
you know,
test
is not going to solve our problem for that set of cases, which is not this case. This case, what's problematic about it is that the courts keep deciding the same way, and nobody really thinks that the lower courts are going to do anything different. Right. And for that reason, it does present the catch me if you can problem that Justice Jackson said, and the problem of how are we ever going to get a case here. But our general case is not like that, and I just want you to sort of comment on it.
I'd say first that the government's proposal of channeling through Rule 23 does nothing to solve anything you just described.
Yes, it does.
I think the limiting principles that I was proposing, which again was just me trying to reflect back to the court, kind of the through lines that it's been identifying, are sufficiently concrete that if this court were to articulate them, it would cut back on the number of universal injunctions. Is it a facial challenge? Does it involve a fundamental constitutional right?
Right. They got to go through that hurdle.
Those are concrete questions. And then I would point to Justice Kavanaugh's Poe concurrence. I think vertical stare decisis is going to be important here. When courts enter these sorts of injunctions, they are immediately appealable to the courts of appeals. So if there are any district courts that are kind of getting over their skis on these, it's correctable by the courts of appeals.
Justice Gorsuch, Justice Kavanaugh?
Some of your concerns about this court being involved, because I'm not sure I really understand that. When a president or an administration enacts some major new rule, the question ultimately, and it's legally challenged, ultimately it'll be a year or two from now, it'll get here and we'll make a final judgment. But the interim status of that rule, as this case illustrates, and many others, vaccine mandate, eviction moratorium, go down the list, they're really important whether they're in effect for that year or two. And I guess I don't know why you should be concerned or we should be concerned about this court playing a role in this.
Oh, I don't have concerns about that. I was responding to General Sauer's point that this has become pathological in the number of universal injunctions that are making its way onto the court's emergency docket.
Just because there are more significant executive actions over the last three decades.
I certainly agree with that. And
that are at the Loper Bright and our West Virginia versus EPA are arguably some part of that story as well.
I agree completely. And to answer the question you asked General Sauer earlier about why have we seen this proliferation of these universal injunctions, I think it's I would say first that the government, I think, pretty dramatically overstates them. It's double counting TROs and PIs in the same case. But if you look at the number of executive actions in the first 6 weeks of this administration, it's more than any other president issued in a year dating back to 1951 during the Korean War.
But I don't want to it's, it's going back. It's bipartisan phenomenon, completely bipartisan and completely, in my view, well-intentioned because presidents want to get things done.
Right.
And I get that.
I agree with that. I think it's directly correlated to the number of unilateral executive actions we've seen over the last few years. Administrations.
Justice Barrett?
Ms. Corcoran, I just have one question. You said that you're in bucket one, so you felt like you were playing kind of the amici role. I understand why you might think you're in bucket one for the associational point. Do you think you're in bucket one for individual plaintiffs?
So I don't know that I would extract them because the universal.
Well, named plaintiff. Like, let's imagine you had individual plaintiffs that are named members of the association. So I guess what I'm saying is, let's take the association outside of it, and let's just say that we're talking about individual plaintiffs.
So
Would
there,
you put that in bucket one?
So there, I would go to the second injury I had identified earlier, which is if you're asking, our individual plaintiffs have pseudonames right now. That would be contemplating a scenario where they would have to identify themselves to the federal government and say, I am an ace, or I'm the plaintiff in this case, at which point they are immediately vulnerable to deportation, even again if they're here lawfully. We've seen the government removing visa holders and asylum seekers.
Justice Jackson?
So I think I understand your arguments. There's just one little piece of it that is confusing to me, and I hope you can clarify. So if we view the relief in this case and others like it to be a judgment ordering the defendant not to do something that the court has found to be likely, because we're in the interim stage, unlawful, are non-parties in that situation actually getting relief, or are they just incidental beneficiaries of an order requiring the government not to do this harmful thing? I thought it was the latter. Yeah. And that just, the government is told by the court, don't do X. And of course, anybody who would have been harmed by the government doing X is benefited by that. But they're not really, I thought, getting relief. But here's where I get confused, because I thought they're not getting relief because they can't come into court independently and seek a contempt ruling if the government continues to do the thing. They weren't parties. They don't have the judgment. That's what differentiates them from, say, the class action people or the plaintiff people. The reason why we have the rules for class action, et cetera, is because at the end of the day, the members of the class are getting a judgment that they can then use to enforce this obligation as against the government, whereas the people in the universal injunction world are just benefiting if the government actually follows the order.
Yeah, I think that what you're articulating is consistent with a long history of precedent and practice. I mean, it's the classic REM case, right? Making a declaration about property. I think Professor Fander's amicus brief is really helpful on that. He talks about the patent laws. And I think you can see that same instinct in the court's cases that Justice Sotomayor was talking about earlier, right? The railroad rates, Barnett, Pierce v. Society of Sisters.
And I guess my point is that's why we don't need Rule 23, because we're actually doing conceptually a different thing. We're not trying to give all these people, everyone in the world, some sort of enforceable right as against the government. We are simply just doing what courts do, I thought, which is telling the defendant over whom they have personal jurisdiction that they have to stop doing something unlawful. And of course that benefits people. But the thing that confuses me about your argument is that you alluded at the beginning to Rule 71 and suggested that the non-parties could somehow enforce this universal injunction. I didn't understand.
I think Rule 71 contemplates that. It would be very onerous. I mean, I think when General Sauer, he was kind of contemplating the idea that, tens of thousands of people were going to have to come to court individually.
Right, but I think if you're right about that, it undermines the point that I'm making, because it puts people in the same place as the class action folks and the parties in a way that I think raises legitimate concerns that some of my colleagues have put forward with respect to universal injunctions. So the thing that distinguishes them is that universal injunctions are not benefiting or giving relief to non-parties in any meaningful sense, is my theory.
I think both have always been true, and maybe they're in tension with each other, but Rule 71's originated in Equity Rule X, which was enacted was put in place in 1842, which had this same idea of, quite apart from representative suits, non-parties enforcing orders that provided them with relief. Although maybe this, as I'm talking, I think maybe I'm talking about under Rule 71, orders that provide relief.
But let me just
You're talking about injunctions.
Yes,
right.
what I'm asking you is,
in
this very case, if we have a series of of plaintiffs, have actually named people, and they get an injunction, as the government says, against if they get a universal injunction, of what they call a universal injunction, the government cannot enforce this executive order. Can someone who is not a non-plaintiff come into court to enforce that if the government violates it?
So I'm hesitant to say no, both because Rule 71 exists and those aren't my clients are my plaintiffs, and we needed this universal injunction.
Yes, I understand. I'm just trying to figure this out.
But I think both, I think both what you said is true. If we look at cases like Barnett and Pierce and we go all the way back, I think Justice Story's dissent that he signed on to in Cherokee Nation v. Georgia is terrific on this point. He was the preeminent scholar on equitable remedies, and he certainly thought, in the way that you're articulating, we are going to make a declaration about whether Georgia can enforce its laws on Cherokee Nation property, and that is just a declaration of the law that will have an impact on everyone. But I'm hesitant to say that Rule 71 doesn't have any application.
Thank you.
Thank you, counsel. Rebuttal, General Sauer.
Trump administration, back up.
Thank you, Mr. Chief Justice.
Close it out.
The original meaning of the Citizenship Clause extended citizenship to the children of former slaves, not to people who are unlawfully or temporarily present in the United States.
That's right.
The merits arguments we are presenting to the lower courts are compelling. We cite, for example, a host of 19th century authorities that point out that domicile was the touchstone of non-citizens being treated as, having their offspring treated as citizens in that context. That is consistent with Wong Kim Ark as well as with the slaughterhouse cases in Elk against Wilkins.
Yes.
And the suggestion that our position on the merits is weak is profoundly mistaken.
Yes.
And that kind of snap judgment on the merits that was presented in the lower courts is exactly the problem with the issue of racing to issue these nationwide injunctions. The Chief Justice correctly pointed out that this court, if it wishes to address the merits expeditiously, has many tools to do so. Cert before judgment is one possible tool. There are also others. But this court should also address the scope of remedy, the remedial question that's presented in the application. That is an extremely urgent question. And one of the reasons it's an extremely urgent question is the limiting principles that my friends on the other side have been offering have all proven to be completely ineffective to slowing the essentially flood or cascade of universal injunctions that we see in these cases.
Everywhere.
The states here have a unique issue that hasn't come up yet, but for the reasons we state in our application, they lack third-party standing very clearly under cases like Murphy and Hayland and Katzenbach and Kowalski. So no injunctive relief should run to the states in this particular case anyway. And most fundamentally, the vision of the district courts that's reflected in the issuance of these nationwide injunctions is a vision of them as a roving commission to correct every legal wrong that they can consider and to exercise general legal oversight over the executive branch, which is what this court rejected in TransUnion. And for those reasons, we ask the court to grant the applications.
Thank you, counsel. The case is submitted.
All right, my friend. So that is it out of the Supreme Court.
Until Thursday, the 22nd of May at 10 o'clock.
All right, that is the Supreme Court. So oral arguments there on birthright citizenship. We got a little bit into the merits of birthright citizenship and the history of it and where it came from and why it exists and all the things. But the bulk of the conversation was about these universal injunctions that we've been covering a lot here over the last several months. Ever since Trump came in, we've seen forum shopping occur by Democratic groups, ACLU gangbang lawyers and other entities, unions, and in this case, state AGs, suing to try to stop Trump and the Trump administration from enacting the will of the American people, since, they were just elected by us not too long ago. And so let's break down what happened there today. I think it's going to be very curious. We're going to have a little bit of a tough go on this one, just based on what we heard today. And so let's go through the various judges. Now, as a general principle, as a general matter, courts don't like to be told they don't have the power to do something. To say, we can do this, we are doing it, and you're telling us, executive branch, that we can't, that the Constitution limits us. Courts generally are not in favor of that. Anywhere you go, right? Anytime you talk to a judge, you can't do that. They go, oh, what? Because it's their courtroom, and because just like anybody, right, they don't like to be challenged when they think that they have authority. So as a general rule, we're fighting an uphill battle on this case, walking into the court to say, hey, Supreme Court, you actually can't do these things because the power doesn't extend for district courts to issue nationwide injunctions to invalidate an executive action. If the Supreme Court wants to do that, that's a whole separate conversation. If they want to bubble this right up and take the case and issue precedent and say what the law is up at that level, that's fine, they can do that. But otherwise, a single level district judge who's often in one district, and in many states there are many districts, saying that he has control over, or she has control over the whole country, absolutely ridiculous. So now, but now going to the court and saying you can't do that, right? You even heard that from many of the liberal judges here, Ketanji and Sotomayor. Are you saying we can't come in here and correct this? Are you saying that these kids? Yes, that's what we're saying. Yes, that you don't have the power to do that. If you wanted that power to do that, you should have run for Congress. You should have been a state governor. You should have been the president or something. But as a Supreme Court judge, you don't have the power to enable lower level. The Supreme Court does, but the lower level courts don't. And what we heard a lot about was different mechanisms by which the Supreme Court can get the case, right? Receive the case, and how it should work in the interim until they receive the case. Now, when you go through the various judges, obviously the three libs, Sotomayor, Kagan, and Ketanji, they're going to go reliably left, as they always do. Now, Kagan came out a little bit, and we've seen some other orders because Kagan, her district, her circuit, is getting petitioned a bunch by these various lawsuits, and she's actually rejected some of them, saying, you know, you can't just come to us for every single thing and demand a nationwide injunction or seek some form of relief. And so her circuit has given us some good rulings, but she's a blue judge, so she'll of course go with the left and say that these injunctions universally are completely valid and that there should be nothing done to stop the promulgation of them. So if we just kind of get rid of them and put them all on that one side, you also heard them screeching a lot about the harms. And this is another interesting point I think that they're using to exact their political will, is they just call everything an injunction, or everything is a demand for an injunction. And of course, the injunction and the preliminary, the TRO rules all enable them to talk about the harm, right? Because they're acting quickly to prevent the harm. And so that then gives them this discretionary power to essentially set policy to prevent the harms from happening. And you even heard Sotomayor today screaming about that. The kids and the children and all the things. We know there are different mechanisms for them to bring those claims. You don't have this raw, unrestrained power to just do whatever the heck you want. So we go through them. Now, Clarence Thomas, I think kind of the opposite of the left. He's going to be reliably on the right, and he is not going to be interested in seeing these injunctions continue to go on. And you can see that because he brought this up several times in the conversation where he said things like, when did this start? Oh, 1963, 1940s. He's an originalist. He's going to look back at this and say there was never any basis for this in the first place, so it's got to go. Now, I think you can find the same argument. I think we heard similar from Kavanaugh, right? Saying, well, they still can do this, and there's still the rules you have to follow. Like, you may not like that you're not going to get your class certified, but the rules are the rules. That's why it's written down. Judges just don't have unfettered discretion to do whatever they want. So I think I'd put Kavanaugh over on the right as well. So it's sort of like 3-2 right now. Clarence Thomas, of course, on the right. Now you have Gorsuch. I think we heard from him today, much as we would expect. I don't think he said anything that was too shocking, just kind of walking us through the history. He was very poignant on that third bucket with the Fagenbacher guy who was out asking questions about his three buckets. And Gorsuch repeatedly said to him, well, what about that third bucket? And they kept saying, well, we'll limit these injunctions. We'll set these new tests and these new standards that will make it harder for these partisan political hack judges to do what they're doing. And I don't think that satisfied Gorsuch at all, or Kavanaugh. I don't think that they really were in favor of this new test that created an exception to the rules that enabled them to have basically two bites at the apple, right? If we can't get a class certified, we'll just go to a judge, and the judge can just do this nationwide and cover the whole country. So I don't think that any of them were real in favor of that. So now we put them on the right. So we got 4-3 as it stands. That leaves us with two judges. We got Amy Coney Barrett and John Roberts. Now today, John Roberts was quiet, man. He was quiet. Couldn't really get a good read on him today. He did ask, I think, a question or two about there other mechanisms, right? So in other words, if the court finds this way, are you totally screwed? Or are there other things you can do? And of course there are other things you can do. And so if I'm gonna, think positively about that, Roberts goes on the right, joins the other four, and we get a 5-4 decision that stops these injunctions. Now, that might be a long shot because Amy Coney Barrett certainly did not like that interchange with D. John Sauer, where D. John Sauer was asked specifically, well, what if that circuit court says you can't do this thing? What are you going to do? And his response to Amy Coney Barrett was, well, generally speaking, we will abide by the ruling in the circuit. She said, what do you mean generally? Generally? And that's kind of what I'm mentioning about these judges. They don't like it when you even hint that you're not going to follow the judiciary. That's their house. That's their purview. You are in their arena. So if you're going to say, well, we'll kind of follow it. She said, what did you say to me? She almost had that tone. What, punk? Is almost how she sounded. To D. John Sauer saying, well, it's longstanding DOJ policy to do it this way. It's not anything we're inventing. So just chill out, Amy. And she said, oh, it is. It is longstanding patterns of practice in the DOJ. Are you sure? So we're not real sure where she's going to go, right? And it seems like if you go from her line of questioning, she's going to go and join the ladies on the left. So now we're kind of in a 5-4 situation. John Roberts, as much as anything, he is an institutionalist of the Supreme Court. And so I don't think he's in favor of making any sudden movements. And so he could go the other way as well. So it could be a 5-4 decision, I think, going back in favor of them, in favor of the left, keeping these universal injunctions kind of at the status quo, but cautioning against using them. I have a hard time believing they're going to institute a new test or something or create a new standard that was promoted by that second attorney who was there today. But all in all, didn't go as well, I think, for the government as we would have liked to seen from D. John Sauer. A lot of questions about alternatives and interims, and what do you do if somebody, is really abusive here? What's the proper mechanism and how fast can you go? And there wasn't a lot of, I think, strong responses to, for example, to Sotomayor's hypothetical about the guns and how that might work. And of course, there will be a ruling that comes down from the Supreme Court soon enough. But as it stands, I think that we heard from 3 very sharp lawyers. They all were excellent at what they did. One gentleman's voice was outstanding and fabulous, even more than some of us could bear. But they were there today making their arguments, and the Supreme Court heard them all, and now we'll see what they do with it. But it feels like it's going to be tight, and I can honestly see this going the other way because the pattern has been basically that. John Roberts has had multiple opportunities to to clarify this stuff and to rectify this, and hasn't done it. Didn't do it in the Kilmar case. Didn't do it in the Boasberg case. And now, in lieu of resolving it, he's basically just been kind of scolding them, kind of nudging them. Is this the moment for him to finally put an end to these nationwide injunctions and bring some credibility back to the court? Because if this doesn't happen, we're going to continue this battle every single day, every single time they file one of these, and every time we get a new injunction, we're going to be here screaming about it, and we're going to be asking ourselves why judges can interfere with the democratic process and insurrect away our rights from us, even though we just nominated and elected a president to come in and do these things. And that is the Supreme Court's entire basis for existence, essentially. It's their legitimacy and their credibility. They don't have a lot of other power. They don't have the power of the purse. They don't control or execute the laws with the military. They've got their legitimacy and their credibility. And the longer they allow these forum-shopped, democratically appointed, partisan hack judges to continue to operate in that manner and fashion, we're going to see it. We're going to call it out. We're going to call them what they are. And that is not a good long-term strategy for the court. So we'll see if John Roberts gets it. Honestly, I have my doubts about it. I think that the default rule, if you ask the court to give up something and to say, you're right, we don't have these powers, as a general rule, they just say, no, we'll keep it because like every entity that exists, they want to serve themselves and increase their own power against the will of us, the American people. We'll hope the Supreme Court does something right on this one. Birthright citizenship is obviously a scam. It was never the law under the 14th Amendment. It's been perverted and manipulated throughout our lives and before, and now it's time to rectify a lot of these problems. We're hopeful the Supreme Court will do something meaningful on it today, and we'll be here covering it. Thank you for subscribing and joining as we do. All right, now, my friends, let's see who is here and joining us on the day. We had some great comments and some great donos. Thank you for sending these in and for joining us on this early stream. We're going to see what the news has in store for us today. I think we'll come back later tonight and get into our regular stream, but we'll see what the day has in store. So that will, of course, remain to be seen. But let's see who is here on the day, my friends. And thank you for sending in these donos and for supporting our stream on the day. We got some friends here. What's up? Carson M just became a supporter. Great to see you, Carson M. Thank you for becoming a supporter on the YouTubes. Great to have you. Economath. What's up, Economath? Says, I appreciate the shout out in last night's stream. Heck yeah. Good to see you, Economath. Yeah. Economath had a good comment about the Dugan arrest and all of those issues that we hit yesterday. Good to see you, Economath. Thanks for swinging by. Hey, Doan. Hey, thanks for picking this up now, Rob. Good to see you, Doan. Thanks for joining us. Yeah, on the SCOTUS thing. And it was a big one. That was a big one today. So we'll see what happens. Thank you, Doan. What's up? Pablo Concepcion says, they're going to give the illegals citizenship. I know. Again, we're not exactly on the merits of the citizenship question, but yeah, I know. It certainly seems like we didn't get a lot of what we wanted to hear today. Thank you for that. Pablo Concepcion, thanks for being here for 2 full babies, my man. 18 months. We appreciate it. Steele Manning says, Sotomayor asks questions and won't hear the answers unless it's her lawyer who is up representing her. Then she's perfectly fine with it. She just kind of sits down and actually she helps. She's like, let me help you respond to Alito's comments. And she went through. She came prepared. She had all of her history. She had all of her precedent and was very excited to share her wisdom and knowledge with the lawyers there in her court. Thank you, Steele Manning. Hey, Saintly Beginnings is here. Says, we need live audio of SCOTUS arguments played outside the building so the protesters outside are exposed to views that they wouldn't otherwise hear. Yeah, that's a good question. I wonder if anybody was broadcasting it out there, on a speaker or something like that. But yeah, they could learn something. They should also watch the show. Could learn something here too. Hey, thank you for that, Saintly Beginnings. What's up, DWS? Great to see you, DWS. Thank you for becoming a supporter and for supporting our work. Grab those member streams. Of course, we do Saturday streams also for our members. We'll see you then. Tobo says, to hear oral arguments, judges need to be quiet and listen and stop arguing with them. Sotomayor stopped Thomas from even asking his questions. Liberals are just quite overbearing. I know. They're very almost unaware of their verbal heft. They don't even care, right? It's very rude. Thank you for that, Tobo. Hey, Just Ranting. What's up, Just Ranting? Says, 14 months as a membo. Says, hi, Rob. Look, this is going to be 4-5 against the government. And he could be right about that. So you're thinking that Roberts joins with Amy Coney Barrett and joins the libs? Ugh. I think you could be right about that. Just Ranting. Thanks for being here for 14 months. You're amazing. This one came in from Lil Kim Jong-un. Oh my goodness. Lil Kim Jong-un is here. Oh, he's from North Korea. So we'll read this in his North Korean. We'll just read what he wrote since he's from North Korea. He says, hello, Rob. America do silly. You either North Korean or you not. We no have birthright citizenship. Liberal judges number 10, but you number 1, Rob. Man, thank you, Lil Kim. You come visit. We have egg rolls and kimchi. Wow, that sounds like a fun experience. And we can work in your work camps too. That sounds fun. Lil Kim Jong-un is here endorsing the show. Thank you, Lil Kim. And put that one on my refrigerator with a magnet. Sandy says, Kagan is asking weird questions because she can't think of what to write to rule against Trump and wants to use D. John Sauer's words in her dissent. Kagan says, I know. This is the most ridiculous thing. Kagan says, "Oh, why don't you tell me why you think you're wrong? Why don't you give me your worst argument? What are your biggest failure points in your entire case? Can you tell me that, please?" Well, I don't have any Well, come up with something because I'm taking notes. Ridiculous, right? It's the job of the opposing counsel. It was so funny. It was ridiculous. And then the other guy comes on and they're like, "Wow, you look beautiful today. Your hair's immaculate. Love that voice. Fabulous intonation. Leonard says Dems know that they can't get a single circuit judge to go along with anything. Well, they just want multiple routes and multiple paths to victory. They know if they got to go through class and follow the rules, then the judges lose the discretion to just do whatever they want. And they're currently doing well finding judges who will do whatever they want. Hey, what's up? Lil Kim is back. Lil Kim Jong-un says, I tripped and fell today. Most people would blame Donald Trump for that, but I actually know the reason I tripped is because of climate change. Yeah, it's true. It's terrible. Climate change is going to cause us all to have bruised bodies from falling on the ground. It's either Trump or climate change, or white people too. Christians too. What's up, Fred? Kagan never lets him answer. It's driving me crazy. I know all of them were hitting John Sauer, and the tone against both those sides was totally different, right? And if you want to read into that, the tones against D. John Sauer, even from Amy Coney Barrett, was almost visceral. And then she turned all that off when the other side came up. Great to see you, Fred. What's up? Lil Kim Jong-un is here. Says this is all on Congress. The cowardly Republicans in Congress haven't done a single thing to rein in the judiciary. In fact, Congress now relies on the judiciary to just rewrite or make up laws because Congress refuses to do its constitutional obligation. Being the legislative body, the three branches have been flipped on their heads. It's all upside down now, how it works now. You're exactly right about that. I mean, in the court, it's how can the court not see that? Guys, you're the Supreme Court. You are the court that governs the country, not Judge Boasberg. He's a D.C. District Court judge. So why does he control the country, but you can't? What? How have you lost that power? Hey, what's up? BZ says, Barrett, Jackson, Kagan, and Sotomayor are arguing against Trump instead of the executive branch, right? It's personal for them. Shameful for a Supreme Court justice to do that. They care nothing about the future judicial health of this country. Yeah. Yeah, I mean, and this is a real big problem for all of us. If we don't have a justice system, if the Supreme Court as an institution loses its credibility because they become partisan hacks, more so than they already are, it's not good for anybody. And that's why John Roberts needs to stop this, because every single time one of these liberal judges undermines and usurps the will of the American people out from under us, that is undermining the institution of the judiciary to their own detriment. They think that they're stopping Trump and saving America. They're wrecking their own entity. Rick D says this is exactly what the courts have been saying about having a hearing for every illegal alien before they are deported. So on citizenship, it's bad, but deportation it's a good thing. Well, yeah. And I think we had a great question from G-Men yesterday about the bond hearing. And I was trying to think through that question yesterday about the bond hearing. And that's kind of related to this, because I think that was the point that Dan Goldman made yesterday. That was about bond. And I'm thinking to myself, is he just trying to insert this kind of into criminal law? Like, bond is when you get charged with a crime, you want to get out on bond while the charges are pending. So he's using criminal language. I mean, the reason I had a hard time answering that question is because it's kind of a category error. It's like you're talking about the wrong thing. Like, this is immigration, not criminal charges. But that's exactly right. Is they're trying to squeeze this into criminal processes under Article 3, whereas immigration is Article 2 under the DOJ, right? So they're trying to, it's like a bait and switch. Now, I think Goldman knows better, but he's just dishonest. Sandy, what's up on Local, says, Sotomayor talking about no incentives to bring the case is projection. Dems are doing exactly this in North Dakota and Texas on the Alien Enemies Act and a loss of class certifications. Yeah, well, they're shopping all over the place. Yeah, we've seen it. We've covered most of them. Thank you, Sandy. What's up, Britt? Cormier, what's up, Britt? Yeah, Britt, I saw this one come through. Great comment at the time, too. Sotomayor will allow this guy to complete an answer to a question that she did not ask, but would not let the Fed, Sauer, answer questions that she herself asked. She has made up her mind and does not care about any answer at all. This is a great comment, Brett. It's right. And like they're helping him, like, go, here, come along here. This is it. And here's my case law, Supreme Court judge. I did the research for you. Here you go. Just use this. Totally different tone because we know where they're going on this. Hey, Wendy Ty, what's up, Wendy? Thank you, Wendy, for being a membo for 14 months. You're amazing. Says, thank you, Robert. Thank you, Wendy. We appreciate you. Hey, Lil Kim Jong-un on Locals says, it's actually pretty funny if you think about it. The Supreme Court didn't get this emotional when the courts and judges were allowing America to be invaded and didn't do a damn thing to stop the Democrats from breaking all the federal immigration laws. Or think about all the other lawsuits against the government, like back during COVID or something. Like, where was Sotomayor saying, do you know how many people are going to lose their jobs? Do you know how many people are going to get kicked out of the military and lose their jobs as firemen and police officers and nurses and doctors and everything else under these COVID restrictions? Like, where was she screeching about any of that? Nowhere. They just said, nope, government can do whatever it wants because they have the power to do that. But now when it's illegals, they get more privileges and benefits than you. They can drive around without licenses or insurance. They can beat their spouses. No one cares multiple times. It's a total free-for-all. Senators go have margaritas with them. Sandy, great to see you, says, everyone is ignoring the entire subject of immigration as the sole decision of the president under Article 2. Yeah, we've seen that in the proceedings, right? But they want it to be Article 3. They want to squeeze it into Article 3 because they have a lot more powers there because they want to make them citizens in a de facto manner. Hey, Base Shaman is here. Jacob Chansley, the QAnon shaman. Are you as surprised as I am how few asylum applicants from South Africa have been accepted? Yeah, well, we did talk about that. Base Shaman says, could you keep an eye out in the meddling of the processing of these applications? Definitely. Yeah, we covered that, I think, earlier this week. And I was surprised by that. It was like 53 people or like 57 people is what it was. Just a small group of people with their American flags. I'm like, is that it? Like, we brought in like 13 million people that are illegal, maybe 20, maybe 30. And the entire Episcopalian religion went crazy over those 53 white people. They're like, we hate white people so much that if you're even going to force us to relocate them into America, we're done. We don't want your money. We're out of here because we hate white people. The Episcopalians, I've never seen anything like it. Thank you, Bay Shaman. What's up? Shout out to Jacob Chansley. Hopefully you're following Jacob everywhere you possibly can. Sandy, what's up? Says, Roberts is calling the justices by name in an organized manner, but a free-for-all with Sotomayor and Jackson rambling and interrupting Sauer. Yeah, so it's funny that we just listened to this because John Roberts gave a talk, I think at Georgetown. Was it Georgetown? Which I'm learning a lot more about. Apparently it's an extension of the CIA, which is fun. So Georgetown had Roberts and he came out and he kind of likes the free-for-all. He talked about this because he's the Chief Justice, so he kind of dictates how this goes. He likes the free-for-all, but the other judges kind of don't. And he explained this. He's like, so we kind of do the 5-minute thing and sometimes it gets spicy, but not. So, yeah. Hey, Vengeance is God says, wake up, Robert. I know he probably caught me yawning there when that other lady was speaking. I was like falling asleep. Oh, gosh, wake up. Thank you for the reminder. Pep it up. I appreciate it. Hey, Jester Bob is here. Says, Ketanji Jackson never not confused. I know. She's like, I don't understand this. What is a woman? I don't know. Does it have like boobs or what? Not understanding something. That's why she talks so much. And here is Kavanaugh as a football player. Almost looks like a cowboy outfit wearing number 45 for President Trump. Put me in, coach. I'm Kavanaugh. Hey, Bezzy, what's up, Bezzy? Says, they are altering the Reconstruction Amendments. That's exactly right. The only reparation on the books, a pact between two groups, children and slaves and children of the revolution. Americans need to understand what is happening. And I agree with you, BZ. Thank you for watching this with us and hanging out with us and for being a voice out there, explaining it so people can understand what's going on. What's up? Rocky Water says, hey, Rob, silly morning question. I will, and certainly research this online, but do you know where the idea of a Chief Justice of the SCOTUS came from? I don't see it in Article 3. What is a Chief Justice? Does he hold any power that overrides the other justices? Doesn't make a lot of sense to me anyhow. Cheers, brother. Yeah, it's a good question. I don't know the specific history on it or why there was a Chief Justice or where that ultimately emanates from the Constitution or the Federalist Papers or just the structure of the organization of it. I don't know the details on it, but you should listen to the interview that he did at Georgetown, because he's kind of like the oil that keeps all the gears moving, right? And he's the one who directs the oral arguments and kind of just keeps control over things. So it's a great question, Rocky. Thanks for asking it. Matt Ostrander says, would text, history, and tradition count with this as it does with the Second Amendment? Yeah, I think it's going to depend on who you ask, right? So like the left wing of the court will say things like, the Constitution should be read in accordance with the times, like now, for modern times, kind of like this living, breathing Constitution. Whereas the originalists would say you can't do that. You got to, what did they say and mean at that time? And then apply that now. You can do that maybe, but you can't interpret it according to like now. Like where we're going to what they meant back then was not incursion. They actually meant like military conflict. We know that because it's different today, and they adjust the language to match the current time. So I think it just depends on who you're asking. But I would say, yeah, I mean, the Second Amendment, right? We should go back to the original meanings and interpret it according to the original meanings, not whatever, the ACLU thinks is appropriate right now. Just ranting. What's up? All courts are trying to take control of the USA. Yeah, and that's a big reason why the founders were so skeptical of the courts and did not give them a lot of power because of this very concern. G-Men, how about an amendment where we elect our own federal district judges and they must be born here? Yeah, see, the election thing I think gets a little bit wonky because then the judges start to be acting like politicians. Like it makes me uncomfortable when I see judges acting like politicians in order to get their ships. Because it's a different category. Like a judge is a totally different person in personality than a politician. And we don't want politicians as judges. That's a big part of the problem is we have a lot of these political appointees who are political hacks. Like I think it was Judge Zenas. Many of these judges never were judges before. They just made big donations to the Democratic Party and became judges. Just like Judge John McConnell, right? Lots of money. And then they become political hacks. And I think that's kind of part of the problem. But definitely the born here thing, absolutely born here. I'd like to see that for Congress too, to be honest with you. And across the board, natural born citizenship. I think that should be across the board. Tired of these, people who are not from America coming here and then telling us we should impeach our presidents. Can't even speak English. What? No. Sandy says, and thank you for that. So yeah, I think we would like some modifications. I just don't know what the right answer is on the election of the judges because we saw the election like in Wisconsin and I watched those two at a debate, like that dude and that other female judge. And like it was awkward. It was kind of, I think, beneath what they should be doing. But also, how do you have accountability to them, right? Or maybe an amendment that would lower the standards of removability. So it's just much more easy to remove these. Or you could remove them by maybe popular referendum. Like maybe that's what it is. It's appointed, but you remove them by popular referendum on the back end. You just say, if the people vote, they, it's like kind of like you add in an impeachment mechanism, but the people have it. You just say, we're just going to vote this dude out. Sandy, what's up? I think we see Amy Coney Barrett agree on a small point of Sauer and a big point with the left justices while writing her own opinion. Could be that, yeah. Robert sees his court drowning in respect. You think he'll go with the right? I think you're right about that. It is drowning in disrespect. So you think he'll go with the right? It's a good take, Sandy. This old guy says district courts are the creation of the legislative branch, so they can be changed by the legislative branch, and Congress should do so if SCOTUS doesn't do anything to solve this. Thank you, this old guy. Great to see you. Dark Rogue, what's up, Dark Rogue? Thanks for joining us. Newbie's here, 8 months newbie, almost one full baby in the oven. Said, I had to do it the right way. So should others. You mean to become a citizen here? We're glad you did it. Thank you for doing it the right way, respecting our country and participating in our laws. And there should be a benefit for that. And we appreciate you doing that. Hey, Mark Shaw, district courts are subordinate to federal courts of appeals and their rulings only apply to their circuits. District courts should be no different, and meaning they shouldn't have the power to issue an injunction that extends beyond their geographic district and their region. I agree, Mark. What's going on? John Groom in the house. Thank you, John, for becoming a supporter. Grab the members only stream from yesterday. You can also grab the after party. YouTube friends also have the after party in a weird format from yesterday, but you have that. And we'll see you on Saturday. Thank you, John. Hey, G-Men says, is cohort too advanced a concept for them, so they must dumb it down to bucket instead? Well, that's why I do it. Yeah. I don't know what they're doing in the Supreme Court, but yeah, that's why I do it. Because cohort's way too complicated for me. So bucket, I'm like, I know what a bucket is. Sometimes you can put a bucket on your head. Legal analysis on this channel. Thank you, G-Man. Hey, Uncle Bozy, Rob Gouveia. The vowels outnumber the consonants 2-1, and it's awesome. Yeah, last name's got all 5 vowels in there. And if you call me Robbie, we got the Y too, you know? Hey, Jeffrey Adams, kimchi and whiskey. Now you're talking. Man, I tried kimchi one time and I think I almost died. So I don't know if we'll do that again, but I know some people like it. And whiskey almost killed me too. So it's a bad combo for me, Jeffrey Adams. Calm and free. What's up? Alina Abba in court today. Well, we might have to do another show tonight then and talk about it. Thank you, Calm and Free. Alina Abba. What's up? Don is here. Hey, just don't wander downwind of Lil Kim after the kimchi. Yeah, is that right? Because he'll kill you too. If the kimchi doesn't kill you, Lil Kim will do it with his kimchi. Hey, Heavy Johnny. What's up? Heavy Johnny says, I think Trump is going to solve this with a suspension of habeas corpus. How the court doesn't see the writing on the wall is beyond me, from Heavy Johnny. Well, we'll see what they do. Lady Ice, GSD lady, sharing pictures of her little baby, Carson May, looking cute as can be. Thank you for sharing those, Lady Ice, with our friends over on Locals. We got Sandy's here saying, we don't elect judges because of fear. They become political. Now we have political judges anyway with no accountability at all. Yeah, humans fail as long-term judges either way. Yeah, right. I guess that's right. And how do you avoid it? So it's like you either get political appointees if you don't elect them, or you get political appointees if you elect them. So either way, it's not good. Thank you, Sandy. Dark Rogue, what's up, Dark Rogue? Thank you for the nice dono, says, the only way this can be fixed is by Congress. Even if the Republicans win more seats in House to a supermajority, how much faith can we have in the voters as they will act? They haven't known and seem divided as is. Well, yeah, I mean, the Republicans have both houses of Congress. And so far, you know, I think the justification for why they are not doing much is because they have to get that one big, beautiful bill passed. And if they don't get that done, then everything else is kind of lost, right? So maybe that's why we're not seeing a lot of activity from them. And once that's done, maybe they'll kick it into high gear. But I think you're right about that the Republicans are mostly ineffective so far, as far as we can tell. They're not supporting the Trump administration at all. It's like a one-man show. And maybe their excuse is the one big, beautiful bill, but they got both houses right now. Just do it. Can't even get Ed Martin passed. It's ridiculous. Uncle Bozy, what's up? The only real chance of any constitutional amendments is a convention of the states. All talk of that has died out. I wish Trump would start pushing one. Yeah, I think the concern about that, Uncle Bozy, it's like, if you have you could reform the whole Constitution, I think, in that environment. Like, it makes me nervous. I'm pretty happy with the Constitution as is. I think we should just revert back to that, you know, and like not change that. You know, there's some adjustments, right, that you make, you know, the slavery and the 3/5 and all that stuff. Like that's all positive development. But when it comes to free speech and due process and even the Commerce Clause and all these things, they had it right in the first draft. We don't need to have a second draft because half the country is going to want to get rid of free speech. Half the country, or maybe less than that, but a big significant majority, they'll get rid of the Second Amendment, no problem. You think about the FISA lunatics, what they would bring in about your Fourth Amendment rights, search and seizure rights, and those things. They write that right out of there. So it makes me nervous. Harold Greer, what's up, Harold Greer? Thank you, Harold, for bringing in 5 new Membo friends. We got Jay Knight, Fed Prevo. What's up, Miata Mama? We got Jane Doe and Gleneth Games, gifted membos in the house. Thank you for doing that, our friend Harold. Sandy says, district courts are not binding on other districts. It's illogical that nationwide injunctions break that rule with no explanation other than we think it's unconstitutional and orange mad man bad. Jeff Monhe says, what happens if the court blocks Trump's executive order? On the birthright citizenship stuff, well, then we lose. And birthright citizenship is valid for illegal aliens if they find that to be the case. So hopefully they don't find that and we get some good rulings on this. Let's say what's up to our friends on X at the moment, and then we will wrap it up on the day. Jen Griffin. Hey, what's up, Jen Griffin? Just follow Jen over on X. Says, sending you some interesting info on Josh Stein out of North Carolina. Thank you, Jen. Barb Schaefer says, it sounded like they're arguing that 6 million babies need to get benefits. And if 6 million babies don't get benefits, then that's going to be harm to the states. Yep, that's exactly right. What's up, Jen? B. Torn is here. Says, oral arguments should be visible. Why can't we see what's happening here? Thank you, finance guy. Great to see you. Says, excellent job. Vincent Major says, listening to Sotomayor and Ketanji are both very painful. All of that is true. And what's up, Teutonic Salt? What's up, Tesla? Calm and free. Good to see you over there. Will there be a transcript of this on YouTube? I'm sure there will, yeah. Jenny's over there. Yeah, Jenny. I normally listen to these arguments, but I'd rather eliminate my existence than listen to the female justices. That's true, too. What's up, John Lucy? Krispy Kreme. Why does the party advocating for birthright citizenship have a lawyer who sounds like that? It's a good question. I don't know. I can't answer that one. It's a good question. Hey, and Maggie Aguilera just became a supporter over on the YouTubes as well. Let's see if we got any locals comments over on the locals chat, and then we'll wrap it up on the day because Elliot is wrap it up on the morning. Elliot is dropping some good stuff over here. Dan shared that, and Dan shared those are the lawyers. Elliot's our docket master on locals and gave us a very nice detail on birthright citizenship, it looks like, and immigration. Same with Dan. More updates from Dan. Hardened Patriot says Congress needs to pass a law saying if you came across our borders illegally, then without going through the proper process, then you don't get a process for being removed. Liberal judges equals judgments and assumptions and hypotheticals, says Hardened Patriot. What's up, Denise Korb? Elliot says, and while individuals who are with diplomatic immunity are not generally amenable to criminal prosecution, if they were in no way subject to the jurisdiction, how could they even be expelled? Denise, what's up? Why does it seem the Supreme Court wants to rush this judgment, especially when there are other arguments about the jurisdiction thereof? Tobo, it seems to me that the ladies are assuming that every court judgment is correct. If that were the case, SCOTUS could just go on permanent vacation. I didn't hear the Supreme Court argue that point. SCOTUS has reversed many cases over the years and a number of others. It appears the ladies are joining against the gentlemen again. More docs from Elliot. Check this dockmastership out. Saying here's some more details on Wong Kim Ark and some more from Elliot. More docs even coming from Elliot. Tobo says 404 Media is reporting the Signal app was hacked. And yes, we're still waiting for the appeal on the Tish case, Carrie B. Elliot talking about, it was mentioned that the Supreme Court could opt for cert before judgment. Likely to be a few months before there will be a Court of Appeals ruling on that. And I think the first oral argument on these will be in the 9th next month. Cherry Barham says, Rob, this whole law or whatever it is that gives anyone who shows up at the border more rights than us will be our downfall. We pay our taxes and Democrats give them more than we get. Welfare, Social Security. We're broke and they have everything. They're destroying us. Thank you, rotten Democrats, from Sherry Barham. Gosh, that's such a good comment. Yeah, they can drive around illegally without a license. They can traffic humans. The FBI lets them go. The whole thing is set up to benefit them at our expenses, because the people in power want it that way, because they get more voters, they get more cheap labor, and what do they care? They get rich, the rest of us get exploited. So it's pretty sad and pathetic. We should demand and expect better of our leaders. Maggie and Elliot Franco, thank you both for becoming members and supporters on the day. And I see MD Kelly also brought in 5 more membos as we wrap it up on the morning. The Three Bears, what's up? Baja got gifted a membo. Celestial Rose, Arrow Spark, and Eric Kennedy gifted membos on the morning. And so, my friends, what a beautiful treat and a beautiful day it has been to be able to go through the Supreme Court stuff with you. Of course, we're going to keep our eye on this one big time. We'll see when the Supreme Court has a ruling for us, but we're going to leave it there on the morning. And the plan is to come back this afternoon. Might be a little bit of a shorter stream since this was kind of the big meatball on the day, but we'll see what the news has in store for us. See if there's any updates in any of the other cases and see what's happened this morning. And then we'll plan on being back here this afternoon, unless you hear differently in the meantime. But my friends, it has been a beautiful stream. Thanks for hanging with us. We're going to pause there for the morning, and we'll be back this afternoon to get into it again. And so thanks for sending these in. K Bean, Carrie B, thank you both for clipping for us this morning. And to all the mods, Meme Smiths, Doc Masters, Elliot, and the rest of everybody who helps keep this thing together and on track. We appreciate you. We'll pause there for the morning. I hope that you're out there on this incredible Thursday, getting after it, baby, accomplishing everything you set your mind to, clearing out your emails, responding to all your text messages, and accomplishing the day's tasks. We're going to be back here in a few short hours to get into it again at the same time. Same place, same location. We are going to need to see you right back here to get into it again so we can scream the spotlight shout out at the end of the show. Until then, my friends, I hope that you're out there getting after it, making it a great and beautiful day. I'll see you right back here in a few short hours soon. Until then, be well and bye-bye.